with Mario Fernandez?
Maybe. Most of my conversations were strictly with Shanna.
In your meeting with Mario Fernandez, did you think that he was a boastful individual?
I did.
Did you think he would brag about being able to do things that you believed he could not do?
I did.
And was that, just describe a little bit more for us?
Mario was always a big talker. I always believed that he wanted to be the biggest person in the room. His personality was such that he always had a story about everything. He always had, he always knew somebody. That was his personality. He had a very big personality.
And did that big personality sometimes relate to his Navy career?
I think it was Army, but
Army,
yes.
Okay. So he would talk about doing big things in the Army.
Yes.
Okay. The did then Shanna Gardner ever share with you statements that Mario made about being able to fix things, take care of things?
And just for
Yes.
the record, I'm objecting as the same objections that I've made in my motion to limine, Your Honor, that you've ruled on.
So just so that I'm clear, this is the objectionable part that you're indicating. There's no objection to the previous testimony? Just so I know that what I'm ruling on.
Yes, well, it's very complicated. There's going to be two separate things that I don't think any of that other stuff get to if this statement doesn't come in and your ruling stands. And I think Mr. Mizrahi agrees to that. Those conversations that Ms. Jensen just testified to, Mr. Mizrahi specifically said that Mario was present for. So obviously there's no marital privilege to that.
Right, so y'all keep doing this. A proffer is get to the objectionable part. So like
I'm
if
not doing
there is no, Mr. Mizrahi, if there is no objection to that, I've heard Ms. Jensen testify before. And so if you could get to the part that you believe I need to make a ruling on, that's what I'd like to get to. If there's no objection to this and other stuff, there's no need for me to hear it.
The state of Florida have to lay some background. This is not a situation where the witnesses testify and we let the jury out. Have to let some background.
I agree.
So I spent 5 minutes laying a background and
Longer than that. Longer than that. Get to it, Mr. Mizrahi.
I am, Your Honor. I'm getting to the point now where that's why he objected.
Well, so I'm sorry, but just to be very clear, that court exhibit, Your Honor, would never come in and we would object to that. But
Okay.
I got it. Move on. Mr. Mizrahi, go ahead.
Yeah. So describe the things that Shanna Gardner shared with you about Mario being able to fix things.
That was his catchphrase. He would say that about all things, no matter what it was. If it had something to do with me, if it had something to do with the kids, that was just a common phrase that he would say.
And did Mario Fernandez share with Shanna Gardner that he could take care of, fix the issues Shanna Gardner was having with Jared Bridegan?
In a family law setting, he would say he believed that they could use the family law courts and fix the problems.
And so that's something that Shanna Gardner shared with you, that Mario says he can fix it, he can take care of it. In a family law setting is what your impression was.
Yes, that was my impression.
So did Shanna Gardner also share with you that he could take care of it because there was a motorcycle gang that was living in close proximity to Jared Bridegan?
When Shanna relayed that statement to me, it was I have eyes.
Okay, and that statement, I have eyes, has to do with Jared Bridegan.
I have eyes on the kids at all times. So yes, I guess.
Did Shanna Gardner share with you that Mario Fernandez shared that he was close on multiple occasions to Jared Bridegan?
I don't know that I remember that.
Did Shanna Gardner share with you that Mario Fernandez had eyes everywhere?
Yes.
Did Shanna Gardner say that Mario Fernandez said that there had been missed opportunities as far as taking care of the situation with Jared Bridegan?
I'm not 100% sure if those were the words.
Well, tell
maybe.
me what you remember.
You're asking me to go through years. I just need you to be more specific, please.
Okay. Well, have you previously testified that there were missed opportunities with regard to Jared Bridegan? Have you had the opportunity to review your grand jury testimony?
I did,
Would you refresh your memory to look at it again?
please.
You have it.
I say grand jury testimony, I really meant your hearing testimony. So would that help?
If you show me.
Look at page 76 of the hearing testimony. Can you go up there?
So what was your question again?
Did Shanna Gardner indicate to you that Mario Fernandez said that there were missed opportunities with regard to Jared Bridegan?
I don't see those words here. Oh, well, maybe down here, maybe.
Point two,
That was a question.
what was your answer?
I don't see an answer here. I said, my answer is, I heard the whole hearing, so I did hear the statements. I don't see where I answered that question.
Well, if you keep going, you do. 18, 19, page 77, lines 18 through 25.
Depending on the question, I guess it's possible, but I don't think so.
Okay. Now, turning to page 78, lines 5 through 7, do you recall the statement? We'll just do it like this, it's quicker.
Okay.
That there was a delay based on COVID?
My answer was, I never said anything about a delay in killing Jared because I never had any knowledge of Jared being killed or planned to kill him.
And then lines 13 through 16?
Not long after that, Mario had made a statement that he never goes anywhere. Neither did anyone else in COVID. Like it just didn't seem, you know what I mean?
I'm gonna ask you a couple more statements and then we'll be done. Do you remember a statement that was made shortly before Jared Bridegan's killing?
Can you be more specific?
Hawaii.
I remember talking to you about Hawaii.
Okay. Tell for the record and tell the court what you remember Shanna Gardner telling you.
Shanna told me that they were getting divorced and how they were going to go about that as far as the kids were concerned. And at some point, Mario asked her if she wanted him to take care of anything. And she said, Jared, and he said, or she said, absolutely not. I don't want anything to happen.
So say that again since you kind of mixed it up.
What did I mix up?
But take care of who?
He asked if there was anything Shanna wanted him to take care of, and she said Jared, and then she said absolutely not.
Okay, so who said Jared?
Shanna.
So I want to break down. Mario Fernandez says, is there anything you want me to do to take care of?
Correct.
And then she said, Jared.
Yes.
And then Mario said, okay.
Mario didn't say anything. She said no.
And then she said no.
And she said absolutely not is what she said.
And this is what Shanna Gardner is relaying to you a week or so before the homicide.
I can't be sure. I told you originally that I wasn't 100% sure which trip that was because every trip had something to do with divorce in the past, in the couple of years prior.
Right. You know when the murder was,
I do.
and you were aware of this statement a couple of weeks before the murder.
If it was that trip, but I said I couldn't be sure because there were many trips.
Okay. All right, Your Honor, that's all the questions I have.
Just so that I'm clear, and y'all can ask whatever questions you need to after the fact. So the Hawaii trip, when you said they are getting a divorce, you mean Miss Gardner and Mr. Fernandez?
Yes.
Okay. All right, Mr. Dreiser.
Ms. Jensen, good morning.
Good morning.
I only have a few questions for you. To be very clear, this is what Miss Gardner is telling you,
Yes.
a conversation that she had with her husband.
Yes.
You have no doubt in your mind that Mario Fernandez did not know that she was sharing these things with you, correct?
Correct.
And Mr. Fernandez you have never heard any of the words that you testified to regarding this last conversation, and most of your testimony, that Mr. Fernandez wasn't present for that. That's what Ms. Gardner was reporting to you that her husband told her, correct?
Yes.
And even that last statement, you don't know what Hawaii trip it happened on, do you?
I don't.
And there were many Hawaii trips, correct?
There were.
And divorce was something that was talked about from time to time with you and Miss Gardner, correct?
Yes.
Regardless of how quickly they got married, Mr. Fernandez loved those children, right? That's what you believe?
I believe that.
And he was an active and engaged stepfather?
He was.
And Mr. Mizrahi didn't ask you in those statements, the questions in between all the different questions, but you would agree you kept telling Mr. Mizrahi that Mr. Fernandez just wanted to keep Ms. Gardner safe. That's what he was referring to in all those questions, right?
Yes.
I don't think I need anything else, Your Honor.
I just want to make sure. So the questions by the defense, those are specifically related to Hawaii, the Hawaii statement.
And all the other statements that Ms. Jenkins said that Mr. Fernandez was not present for. That's what was
That's the problem. So I don't know that the defense needs to do it, but that is the purpose of the ruling. It's not necessarily all these statements. It's the circumstances surrounding the statements that.
I totally agree. That's
So
why
I don't know anything about that to make a ruling. It's the circumstances for which the statements occur.
Circumstances under which the statement, state theory that there's true prong way why this comes.
I understand the state's second theory that it's about child custody. However, I want to be clear. I think about 45% of her testimony could be admissible. I find probably 3 statements that she couldn't make. I don't think that this is admissible. There are no circumstances for the court to make a ruling. However, the facts and the circumstances related to the Hawaii trip, I don't know, were they just made via witness to Miss Gardner or vice versa on a telephone call? Was he sitting on the couch? That's what I mean, the circumstances.
It was a call between Shanna and I. I believe so.
Judge, there's no dispute. Mr. Mizrahi will agree with me. Mr. Fernandez was not present and he did not know that she was ever going to share those communications. So there's nothing in your ruling that you heard today that's different.
Well, I want to be very clear. I did not say that she couldn't testify. Like I said, I think probably about 45%, but for these private text messages back and forth between, I don't know who some of these numbers are,
They're not.
but anyway, you're not. Okay, so I'm not making a ruling on that. You just want it admitted for what purpose?
We didn't know it was any voluntary negotiation.
So as it relates, hold on, let me pause you. As it relates to the co-conspirator statements that passed prior to her marriage of Mr. Fernandez, I'm not excluding that. Okay, so, but you're not admitting this. Okay,
Co-conspirator hearsay statements heard before Mario Fernandez even met these conspirators. Various within potential process application.
okay. All right. So the state is, all right, so you're putting in a court exhibit that you do not intend to actually introduce as evidence. However, the statements, I only really see 3 potential problems with the admission of some of these statements. The Hawaii statement, a private conversation between this witness and,
Main purpose, why I'm doing all this once. That is why I'm on the proper Friday, why I'm putting on proper. Even when they're in privilege, here's.
all right. Thank you, Ms. Jensen. Do you have anything further for Ms. Jensen?
No, can I have 1 minute with counsel?
Okay.
The state and I haven't, I think we understand, and it wasn't as clear, but I agree with the court. Anything that she heard Mr. Fernandez say, it would be admissible if the state so chooses to call her. I did not object every single time this morning because I
Right.
was trying to get through it. Most of what she testified to was just what Ms. Gardner told her, and the state agrees with me. They're not calling her to put any of that in. So just so the court's aware, I would have objected to every single question where she was reporting what Ms. Gardner told her Mr. Fernandez said. With that being said, I think the witness can be excused.
All right. Just temporarily so that I can make a ruling. Okay.
Okay.
Thank you. No. Thank you. So I wrote in the court's order, the state's secondary theory related to Ms. Jensen. I've rejected that line of thought. I saw no support in the law nor the rule that would allow the state to submit that statement and pierce the marital privilege. I left open the potential that if there were circumstances surrounding the actual statement that would basically the privacy would fall away, the circumstances for which it was made. But generally speaking, I believe that the exceptions to the marital privilege outside of the privacy area are well defined. It is a crime against either one of their children. AB and LB are not, are Miss Gardner's child. But none of what I saw, unless I'll hear you out, changes the court's analysis. So I'll hear you if you want.
Yeah, just very briefly. Thank you,
Okay.
Your Honor. The AB and LB are victims of an intentional act that reasonably could lead to their physical or mental injury. Because this is not a murder that is done for a gang relief reason or for money reasons. And tangentially, those children are injured. The goal and purpose of this homicide was to take away Jared Bridegan's parental rights to eliminate their father intentionally. This was the intentional act done that could lead to their physical or mental injury. LB and AB are children of Shanna Gardner. Therefore, she has the ability, her statement pierces the marital privilege because it's a statement about the homicide involving her two children. That's the theory. The reason why we put on Mr. Ponder yesterday is it was direct evidence from the defendant's mouth to Mr. Ponder's ears that the purpose of this homicide, the purpose he hired someone to do this, was for child custody issues. So this isn't the act itself was an intentional act to inflict physical or mental injury upon these children. In addition to obviously Mr. Bridegan, but that was the goal of it. In order to prove a child abuse, that the act has to be intentional. So the court's concerned that it was just some random act of violence. That would not be intentionally to the children. The court.
That's not my concern.
Okay.
What criminal case has ever centered on child abuse where the children are physically safe in their house and let's say the other spouse gets beat up, or let's say it's that beat up by the other spouse, and then somehow that pierces some sort of marital privilege. AB and LB, I believe we all could agree, were safe at home, dropped off, physically safe. So the mental argument by the state is that, I guess, do you know a case where that's been the child abuse theory?
There are cases where the child abuse theory has been premised on mental injury, 100%. There is not a case that deals with child abuse that mental injury is the reason to pierce marital privilege.
No. Have you seen a child abuse case where one parent is trying to get custody over another parent and therefore the state of Florida intervened with criminal sanctions saying that, no, that's child abuse?
No, there is not a child abuse that I'm aware of, at least an appellate case, an opinion case, where the murdering or injuring of another parent for child custody.
I'm not talking about, let's say not murder. Let's say just a third-degree child abuse where the state of Florida goes and arrests another parent because they want more custody than another parent.
Well, that would never be a child abuse.
Okay, but that would be mental That would be mental injury on the child potentially, right?
No, no.
Okay.
Talk about murdering their father.
All right.
It
What
has nothing to
about
do with
breaking their
legal-
legs?
Well, no,
Breaking their legs or doing something horrible to
Breaking-
the other parent?
That doesn't interfere with their custody. They still have custody of their child if they're beaten up, if their legs are broken, if they go to the courts. That's all legal methods. You're talking about the only true way that they could eliminate custody. The only way they could take this father away from his children was to murder him. There is no other way. That's our theory, is that that was done intentionally, and that reasonably could lead to the children's injury. It's a very unique set of circumstances. Certainly, we don't have third-degree child abuses under that premise because it wouldn't exist. We do have third-degree child abuses with an act that could intentionally lead to mental injury to a child. Those exist.
Quote me a case.
I don't have a case right off the top of my head. It's the statute. And there are certainly premises under the statute, under 82703, it says an act that reasonably could lead to the physical or mental injury of the child. We have to be able to prove those elements. But there's not a, I could probably find one. I don't have it at the top of my mind because there's not one. I concur with the court. There's not going to be a case that says that pierces marital privilege. There are, and I submitted in our argument, cases where the reckless driving pierced marital privilege.
Right, but that was one parent that was driving and then injured the child. That's, in my mind, so factually distinct from this scenario.
I don't think the child was injured at all, Your Honor. If you read the case, that child
I-
was subject.
I've read a lot of cases very recently, so I apologize for getting it, but I believe that it related to the child. I'll pull it back
Yeah,
up.
the child was in the car and the person was driving recklessly, and that can lead, that was considered a child neglect. It wasn't an abuse, it was neglect. For failure to provide the care necessary for the child's well-being by driving recklessly while the child was in the car. I agree that was, the child was in the car when the recklessness occurred. But it doesn't change the state's argument that the intentional act was to eliminate the parental rights and take away these children's father.
That case also went to the premise of the psychopatient privilege. That's what the court was ruling on, not the marital privilege. They punted, or they didn't need to go to the marital privilege because they relied on the psychopatient privilege, which does not have the same elements as the marital privilege. This, I'll just wait.
So there's a Florida Supreme Court case, Dufresne, Dufresne v. State. It's a Florida Supreme Court case, 826 Southern Second 272, that goes through, I guess there was a challenge to the phrase mental injury, where there was a constitutional challenge for vagueness, and it goes through the history where it falls. The Florida Supreme Court, it says that we know the definition of mental injury now found in 39, that's when they redid the statute, this is a 2002 case, is a limiting definition as opposed to a broad definition, which benefits the defendant. Thus, mental injury as defined will present only in limited circumstances, thereby discouraging arbitrary and discriminatory enforcement. Accordingly, pursuant to this analytical framework, which sets forth in Fuchs, we conclude that the district court properly held that the challenge statute is not unconstitutionally vague. Mental injury is adequately defined, is what it says. And I'll go back up to what they are affirming is not vague, which in 39, I know the state is focusing on the intentional part because your theory is that the murder is the intentional act that would somehow produce this, which is mental injury means an injury to the intellectual or psychological capacity of a child as evidenced by a discernible and substantial impairment in the ability to function within the normal range of performance and behavior. And so you're saying that LB and AB, that is the fact. So I would need more facts there.
I understand the court's, I understand that law. I'm very well in the mental injury law. And what is required, I would point your honor to Hill v. State, which I argued at our last hearing at 846 Southern Second 1208 of 2003.
Repeat the last numbers.
I'm sorry, 846 Southern Second 1208. It's a 2003 Fifth DCA case, and under head note 5, 6, and 7. Your Honor, we don't have to prove beyond it to the exclusion of a reasonable doubt that a child abuse occurred. In fact, the court quotes, and I'll read it for your honor, although we have found no case in which the defendant has been convicted of this crime of child neglect based on reckless driving of a vehicle, if the defendant's reckless driving is shown to be sufficiently gross, there is no reason why the charge could not be proven. Because of the clear statutory language in both section 39, which is what we're going on, we agree with the trial court that the psychotherapist patient privilege does not exist in this case as to any communications relevant to the child neglect felony count. So the law doesn't require you to prove.
I'm not putting that burden on the state.
Sorry, what?
I'm not putting that burden on the state. I don't want you to even argue that. I'm not putting that on there. However, I do have to find that that would be potentially a child abuse, correct? In some form. I'm not saying that you have to prove beyond a reasonable doubt each and every element. And I don't want you to think that I'm doing that.
Okay.
And as well as I don't want you to put on an entire proffer of things that I probably about 80% I would allow. I'm not putting the state in a box like that. Instead, I don't know, just like the state is being cautious, saying that we don't want to put in evidence that there was a pre-existing conspiracy for confrontation. That's your choice. That's your strategic choice. However, I need a legal path to admissibility. Admissibility isn't beyond a reasonable doubt. So I want that to be very clear. I'm not putting that burden on the state.
Okay.
But I do, you would agree, Mr. Mizrahi, that this is unorthodox.
I wouldn't call it unorthodox. I would call it using the law to get in pieces of evidence. That's what I would call it. I wouldn't call it unorthodox.
All right. So Earhart is like my favorite book.
I love it too. I've seen
Okay.
him lecture many times.
Me too. All right.
You have.
Total fan club. However, I don't see the Earhart has anything.
It
And
doesn't.
he is a guru on evidence that would even suggest a path like this.
My argument to the court's last inquiry about whether or not it is inconceivable that a 9-year-old child whose father has been murdered would not have some discernible psychological issues as a result of the elimination of that parent. This is not unorthodox or way out there. It is incredibly logical that if a child loses a parent, that they will be subject to some type of psychological damage as a result of it, discernible as required by Dufresne. So I think the court's analysis ends there. Is that reasonable? Yes, I think that's reasonable. Therefore, it pierces husband-wife privilege and it is admissible. That is the state's argument. And if the court, I agree with the court that there is not a case on point on all fours that deals with this issue. I agree with that. I agree that with the reckless driving, the child is in the car. This is a mental injury situation as opposed to a reckless driving situation when the child is in the car. Those are two different scenarios.
Well, let me ask you this.
Can I,
I'm still messing. I've got to figure out what Mr. Mizrahi is, what his path to admissibility. And he keeps saying all these much higher hurdles that I'm not putting on the state.
Okay.
My
And so
objection-
let me go ahead. What's your objection?
my objection is, and I've been quiet and letting the court and Mr. Mizrahi go, is that you made a ruling and you gave a pathway to the state to see if they could breach the marital privilege. And they put on their proffer. There was no breach of the marital privilege. And now Mr. Mizrahi is getting essentially now what's been 30 minutes of an opportunity to re-argue and start citing case law, cases you've already ruled on, you've already read, that is not what today's hearing was for. It was, your ruling was very clear. If they can breach the privacy, then you made the ruling. You've read Hill. You've read all these cases. So I'm just sitting here letting him get a second bite at the apple in the middle of the trial. And I think that's unorthodox. I think your ruling, which was written, well thought, well written, and took time and days before we got a decision, is now just being relitigated on the very premise of not what you said they could do, which is break the marital privilege. And that is frustrating as I sit here and allow this to go on, but it's as you see fit, Your Honor.
So this is where I'm at. In that hearing, there was the opportunity to call these witnesses. It didn't happen. The state is able to make a record, which they're allowed to do, which is a proffer. And while I don't necessarily, generally speaking, proffers are the objectionable evidence and their record needs to be clear, Mr. Dreiser, that generally speaking, the proffer only includes what is being objected to. Like I said, I don't want the appellate court to be under the impression that I ruled all of that inadmissible, which I did not. I don't want the state to make a record saying that I'm saying that it's not admissible because they have to prove something beyond a reasonable doubt. It is not. I know the rules of evidence. So I don't want, that is what I'm doing. Okay. So as far as that is concerned, I have heard part of this. I haven't seen it in real life. I did not know what the purpose of Mr. Ponder was or what he was saying, I guess, at the very end. And then I want to make sure that the record, what you're objecting to is the Hawaii statement. And then this, some other statement that was made on the phone, but there were statements put in that apparently Mr. Fernandez was here for. And so that would not be marital privilege. That is not inadmissible.
I agree.
And so my last question for Mr. Mizrahi is that the statements that you were seeking to admit where you're saying it was related to child custody, you're depending on Mr. Ponder, not for Ms. Jensen, because she said that Mr. Fernandez said he was going to fix things through the family law system.
Well, it's both.
It's both. Okay.
It's both. The Ms. Jensen doesn't say that Mr. Fernandez said he was going to kill Jared Bridegan for child custody. That's why we put the Ponder on. That,
Okay.
the Ponder statement is the direct evidence, the murder is done with
Let's
a
be,
child abuse.
All right.
Mr. Ponder did not need to be proffered. I agree. You weren't making a decision as to whether what he could say comes into evidence. You were very clear about that, and I agree with the court. They just chose not to call Mr. Ponder for strategic reasons. They had no, Mr. Ponder,
They
Good.
have?
yes, they have chosen not to call him,
Okay.
and they brought him in to tell you evidence that the jury has not heard that could come in. He can say what Mr. Fernandez told him, and then I'll cross-examine him, and the jury will decide what they're going to do with Mr. Ponder. But now they're trying to get in what Mr. Ponder said to influence your ruling, when that's not, I don't know why they proffered it, quite frankly. I guess to stack inferences, but Mr. Ponder could have testified in front of the jury. He wasn't saying anything, as you said. You don't make determinations on believability. You make legal decisions. There was no legal objection that I know of that I could prevent Mr. Ponder from testifying. So let's be very clear about that.
Okay. Well, I didn't know the state wasn't calling him, so. All right. If you, Mr. Mizrahi, I stopped you because I thought he was going to testify and they'd hear all of that stuff. I needed to make a legal ruling, but if you wanted to put him on again to, I guess, or put his deposition in, I don't know. But I stopped you because I thought he was going to testify.
The state does not need to recall Mr. Ponder for any purpose of profit.
All right. So,
We have put on the evidence that we think the court can make this decision, and we understand the court's previous ruling, and I've made my argument, so we're good.
all right, I'll maintain the ruling. Are y'all ready to get started?
Yes, Your Honor.
Ms. Jensen, you don't want her anymore?
Excuse, and needs to be appear for the Gardner case. And she's under subpoena.
Johnson's.
Okay, thank you. Nice meeting you. Ready?
See.
And Mr. Hathaway, will you get that exhibit? Who's the state calling?
Fred Barton, Your Honor.
Thank you. I'm waiting for them to
Sorry, I
be
didn't hear
ready.
that in the conversation.
Thank you. Welcome in, members of the jury. Everyone may be seated. Welcome back, members of the jury. I hope that you all enjoyed your weekend. We are in the 6th day of trial. I want to, before we begin the proceedings today, just confirm that you all followed the communication rule over the weekend's recess. If you could all answer out loud. Okay, great. Now, to remind you where we are procedurally, the state of Florida is presenting their case. They're going to call their next witness. Ms. Stifler,
Your Honor, the state calls Fred Barton.
Fred Barton, please. Good morning, Mr. Barton. Come all the way forward, please. All right, raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Okay, sir, go right to your left and then be seated in the chair. Pull yourself all the way up so that you're speaking into the microphone, okay? You may proceed.
Thank you, Your Honor. Good morning, sir.
Good morning.
Can you hear me okay?
Very well.
Thank you. Could you please state your name for the record, introduce yourself to our jurors, please?
My name is Fred Barton.
And Mr. Barton, do you live here in Duval County, Florida?
Yes, ma'am.
How long have you lived here in Jacksonville?
Uh, since I retired from the Navy, 2002.
And what do you do for a living, sir?
I'm a manager for Allied Security Company.
I'm going to keep this brief because I know you got to get back to work. I want to ask you about an incident that occurred several years ago with a man named John Biggerstaff.
Mhm.
Do you know John Biggerstaff?
I do.
Can you tell the jury when you met Mr. Biggerstaff originally?
I can't remember exactly, but I met him years ago through his wife, who I met on a dating app.
Okay, and you had some kind of dating relationship with his wife?
That's correct.
She was married to Mr. Biggerstaff at the time.
That's correct.
And did you and Mr. Biggerstaff have any type of interaction yourselves?
No, just when I went around the house, he was there, or he would bring her to my house. She would stay with me on the weekends.
No problems with him. This was a consensual, everyone's copacetic type of relationship.
If you could say yes or
Yes.
no, please.
Thank you, sir. At some point, did you become aware that Mr. Biggerstaff was being federally prosecuted?
I did.
And during that time, did you know that he was going back and forth to federal court during his case?
I did.
And I want to ask you about, while he was litigating his case, did he ask you to hold an item for him?
He did.
And did he bring that item to your home?
He did.
Can you tell the jury what that item was?
It was a metal cabinet. He called it a gun cabinet, but I don't call it a gun cabinet, but it was a metal cabinet. And he brought it to my house, asked for me to hold it until his son would pick it up the following week on Friday.
And I know you can't remember the exact year, but in the timeline of his case, when did he bring this gun cabinet to your house?
The last conversation I remember having him with him was based on his attorney advised him that he needed to get rid of those guns or any firearms in which he had possession of, because if he was convicted, he wouldn't be able to touch them, do anything with them. So he was giving them to his son.
Okay, so this was prior to his sentencing, but after he was originally arrested and litigating his case.
That is correct.
When he brought the locker over, where did you store it at your home?
In my closet, in my bedroom.
How did he bring it over?
He came over and I put it on a hand truck, and he brought it to my room. I put it in my room, and locked my room, because I locked my room on the outside because my kids used to break in my room. So I locked my bedroom also to keep them from breaking in my bedroom.
Okay, and so he brought it on, he said a hand truck.
Mhm.
What is that? Like a dolly?
Well, it's a hand truck. You just pull it back and you roll it however you gotta.
Did you ever look inside the gun cabinet?
Never had access to it. Told him I didn't want access to it. I don't want to have any responsibility if anything's missing, damaged when he picked it up. So I couldn't tell you what was in it.
You couldn't tell what type of firearms were in there.
I wouldn't even know if there's firearms in it because we never opened it prior to him leaving it. We didn't open it when he came to pick it up.
Right. So you never looked inside.
Mm-mm.
You wouldn't know what's inside other than his statements to you that
That's
it was
correct.
a gun cabinet and his lawyer told you to take it with his
That is
guns.
correct.
Who came and picked it up?
Him and his son,
And what's his son's name?
Juan.
How long after Mr. Biggerstaff dropped off the gun cabinet did they come pick it up?
It's about a week, the following Friday.
Did you keep any firearms or ammunition that Mr. Biggerstaff brought to your home?
No,
Would any of his firearms or ammunition, if they were in that gun cabinet, have been left at your home?
no,
Do you have any of Mr. Biggerstaff's firearms or ammunition to this day?
no.
And you're obviously in your job at Allied Security, you're lawfully allowed to possess and own firearms.
Yes, I have a gun from them.
Do you know the defendant in this case, Mario Fernandez?
Never heard of him.
Do you know a woman named Shanna Gardner?
Never heard of him.
Do you know a man named Henry Tenon?
Never heard of him.
Do you know a man named Jared Bridegan?
Never heard of him.
I have a moment with counsel, Your Honor.
Yes,
No further questions. Thank you, Mr. Barton.
thank you. Cross?
Yes, Your Honor. Good morning, Mr. Martin.
Good morning.
Nice to meet you. My name is James Hill. I represent Mario Fernandez.
Mhm.
If I understood correctly from your testimony, sometime in a year that you don't recall, Mr. Biggerstaff brought over this cabinet as you described it.
Mm-hmm.
Is that a yes?
Yes,
Sorry, we just have a court reporter. She needs to hear exactly what your answer is.
I got you.
My understanding is you never opened that cabinet.
That's correct.
No idea what was in it, correct?
That's correct.
And if there were firearms, no idea how many.
That's correct.
Certainly no idea what make and model of those firearms.
Say that one more time.
You wouldn't know what make or model of firearms in a cabinet you've never opened.
He never opened it. I never opened it. He never opened it. I never wanted it to be open.
Understood. And that was about a week it was in your closet.
That's correct.
After that, you testified that his son Juan
And him.
came and retrieved that cabinet.
That's correct.
Where it went after that, you have no idea.
I've never seen or spoke to them ever since that.
And certainly you would not have given firearms to a convicted felon, correct?
I definitely wouldn't have done that.
As to whether or not that cabinet was transported somewhere else and opened, you wouldn't be able to testify to that.
I wouldn't know what they did with it once they left my porch.
And what year do you believe this?
I don't recall what year it was.
And ultimately, you and Mr. Biggerstaff had a falling out later on. Is that correct?
Well, I distanced myself once he got convicted of what he told me he was innocent of
You and John Biggerstaff no longer had a relationship at that point.
at all. Not at all.
And I know Ms. Stifler asked you whether or not you knew Mario Fernandez. That name means nothing to you other than maybe at the top of the subpoena that you were served.
That's correct.
And so you have no information as it relates to the homicide of a man named Jared Bridegan.
Except for what I see on the internet.
But you personally have no information as to,
Never seen him before in my life. Never heard of him.
and certainly no information as it relates to Mario Fernandez and the homicide of Jared Bridegan.
That's correct.
I have just a moment, Your Honor.
Yes.
No further questions for Mr. Martin.
All right. Any redirect? Thank you.
You be excused.
All right. Thank you very much, Mr. Barton. You can step down. Call your next witness.
State calls John Biggerstaff.
John Biggerstaff, please.
Or he has a walker, so he may take it.
Okay. Okay. Good morning, Mr. Biggerstaff. If you could walk all the way forward, please. Good morning. Can you raise your right hand to be sworn in?
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
Sir, if you'll make your way over to your right. Officer, I'm sorry, Mr. Holman, can you help him with his walker as well? Just get yourself situated in the chair, okay?
I need these two things. I need to purchase the 10mm document and the inventory.
You have to pull yourself up and talk into the microphone.
Just a little bit. The inventory, 10mm. Yeah. And the purchase of the 10mm.
Mr. Mizrahi, when you're ready.
Thank you, may it please the court. Counsel,
Thank you.
good morning.
Morning, sir.
Please state your name for the record.
John Robert Biggerstaff.
And are you a convicted felon?
Yes, I am.
When did you become a convicted felon?
When I pled to felony misprision in 2017.
2017. At the time, before you became a convicted felon, did you have to get rid of your guns?
All of my weapons, yes, sir.
Okay, and that's why we're here. You know, that's why we're here to talk about that.
I understand that, yes, sir.
Did you purchase a 10mm firearm?
Yes, I did.
When did you purchase a 10mm firearm?
I don't know the exact year, but it was prior to 2016.
Why did you purchase a 10mm firearm?
I was a member of a hunting club for a few years up in South Georgia. And where I was making my hunting stand, there were bears. Did some research and talked to a friend of mine who suggested two different kinds of weapons, a Casco 454, I think it was, and a 10mm Glock. Having served with JSO and my military experience, I preferred the Glock weapons over anything else that I was unfamiliar with.
Where's your gun now?
I have no idea, sir.
No idea where your 10mm firearm is.
No, sir.
Do you regularly take gabapentin? I'm not going to get into your medical history, but you mentioned that in deposition.
Yeah, I'm sorry. What did you say?
Gabapentin, do you normally take that?
Yes, sir.
Are you on that right now?
Yes, sir.
Okay. And what is that?
Gabapentin is for nerve pain.
And are you still able to perform your daily functions having taken that prescription drug?
I don't know what you mean by daily functions, no, sir.
What'd you say?
I don't know what you mean by daily functions.
You're able to come here and testify.
I'm able to come here and testify, correct?
There you go. Were you in the Navy?
Yes, I was in the Navy.
Tell the jury about your career.
I was in the Navy on active duty from July 86 until October 1st, 2007. Served on active duty as a cryptologic technician collection specialist.
What does that mean?
Um,
What you can share with us, what is it?
Cryptologic technician collection specialist changes with technology and threats as perceived by the U.S. government, National Security Agency. I maintain a top secret sensitive compartment and information facility type of access for my 21 years plus. When I first came in, I was it's known now as an HF manual Morse intercept operator. Over the years, I learned some different languages and performed different duties.
Well, thank you for your service. Did you also
Thank you.
become a police officer?
I did, yes, sir. I became a JSO reserve officer.
Tell the jury about that.
I ran into somebody who mentioned to me, he was a reserve officer with Jacksonville Sheriff's Office. Thought I'd be a good candidate. Mentioned to me about the academy and so on and so forth. They're in a safety fair, I believe, at Regency Fair or Regency Mall at the time.
Do you have to undergo training?
Yes, yes. Following my knee surgery, I had a physical fitness test the following week and started academy right away. Yeah.
And what years were you a member as a reserve officer with the Jacksonville Sheriff's?
It was about 3 years long, but I don't remember the exact years. Oh, well, yeah, and it ended in 2016 when I was arrested.
And I guess that was my next question. Obviously, you can't be a police officer if you're a convicted felon. Did you have it down, something happened in your life that you've talked about your Navy service and your police service, and did you have some things in your life that led you down a path that you're not proud of?
Sure, absolutely.
All right, just briefly, we don't have to get into all the details, but briefly tell the jury about it.
As a result of severe,
Yes. You may proceed.
Hey, please, the court. So I just, as opposed to that open-ended question, I'm going to ask you two directed questions. Did you end up with financial problems in your life?
Your Honor, if I may.
What?
Okay.
Needs a
Um,
break?
All right. Let me have the jury step in the back, okay? Everyone can be seated. Are they in there, Mr. Holman? Okay. All right. All right. So I'm assuming that the state told him to look at me if he had concerns.
I did not tell him.
You did
that.
not tell him that.
He's
Okay,
educated
so-
enough to probably know that.
All right, Mr. Biggerstaff, I cannot have any type of private conversation with you, but I can do this. So what are your concerns?
Yes, ma'am. My concern is, as a cryptologist, I've been trained to look at everything and listen to everything. So I don't know if I wasn't supposed to hear that conversation over there, but the court reporter has the screen open right in front of me that I can read. I didn't read much, but I just saw that the words going across match what I could overhear over there. And I just want to let you know in case there's something that comes out of that later.
Okay.
I'm sure that either needs to be screened, needs to be closed if you have some kind of a side conversation I'm not supposed to hear, or I need to turn away or something.
All right, so your concern was that you overheard part of what the sidebar was about.
Via the screen, yes, ma'am.
Did you hear it or you read it?
I read it.
Okay. Is any of that causing you a concern?
No, ma'am.
Did the objection cause you any concern?
I didn't hear the objection.
You didn't?
No,
Did you read it?
no, ma'am.
Okay. So I will tell you, since the state didn't, if you do have some concern about, did you tell him some area that he shouldn't get into or not? I'm not sure. With the other witness, there was that issue.
I
I'm
don't-
asking.
I don't think that there's an issue with this witness.
Okay, Mr. Dreiser, do you?
Not that I can think of off the top of my head.
All right. So did you have any concern about your background, sharing that with the jury? I just want to make sure that we can, when I bring him back out, we can go
Military
forward.
background, no, ma'am.
All right.
No.
Okay, I think we're good to go. I don't, unless the lawyers think that there's something wrong, I'm not gonna have Ms. Simpkins put her screen down. Because,
No, Your Honor, we're aware of the issue now, and if the lawyers will bring it to your attention if it needs to be put down for the witness.
okay,
Agree.
well, I can do this. Ms. Simpkins, can you angle it a little differently? I'll go off. No, right now, just angle it down a little bit. Is that good?
Yes, ma'am. I
Okay.
didn't intentionally read the whole thing, but.
For the record, the screen is angled down. Let's bring the jury back. Melanie, you need it up like that? Turn it this way. Okay. Okay. Thank you. Right, welcome back, members of the jury. Everyone may be seated. Members of the jury, pardon the interruption. Mr. Mizrahi?
Please, the court. So Mr. Biggerstaff, we left off with my question about the change in your life. You were in the police, you were a police officer, you were Navy, and did you end up with financial problems?
I had financial problems long before that. Yeah,
Okay.
yeah.
Did you also end up with a drug addiction problem?
As a result of PTSD, drug addiction, depression, anxiety, yes.
I'm just trying to explain to the jury the shift in your life. Would you agree there was a shift in your life?
Yes,
Do you know Mario Fernandez?
I do, yes.
And how do you know him?
I've known him for about 18, 19 years. My daughter caught a ride home from him one day from school, introduced us, and we became workout buddies for a while.
And do you see him here in court?
Yes, I do.
Would you say where he's seated? What he's
He's-
wearing so you can identify him?
Seated to my right,
What color suit is he wearing?
I'm colorblind, but it appears navy blue.
You nailed it. Your Honor, this time the state would ask for the record to reflect the witnesses identified the defendant.
I think they're all in blue.
He said navy blue. Although I think Mr. Dreiser is navy blue.
All right. Yes.
So you explained that you were workout buddies. Just kind of dive into that a little bit for us, please.
Yes, in the mornings, Mario would come over and type his Pitbull 0 to my truck. And we would work out. I had purchased a home novelist gym from Sears many years ago and had it in my garage. It was enclosed. My son was playing football in high school and then on to college. And So we would work out in the mornings. Mario, when he was at home in Jacksonville, would come over and work out some mornings. We'd text each other in the morning, make sure I was up and going to work out. I think I was retired at that time. So I was working for Hewlett Packard and I was on a 100% travel schedule. So in between my traveling, we'd get together and work out at my house. And then he joined the Army at some point and I didn't see him for years.
Okay. When he got back from the Army, did your relationship begin again, so to speak?
Yes.
And did you share experiences in the military with each other?
Yes, occasionally.
Back in 2020, well, let's turn back to 2018. Were you aware of who Shanna Gardner was before you found out that she got married to Mario Fernandez?
No.
Explain to the jury how you found out that they got married.
One day when Mario was at my home, he brought up a picture of him and Shanna, and I believe it was in Hawaii on a honeymoon or something like that, and said he'd been married for, I think he said 2 years, I think at that point. It was at least a year. And that kind of surprised us. So.
And why did it surprise you?
Well, I hadn't seen or heard from Mario in a while. And then to find out that he was married, somebody would consider a family friend, it was kind of shocking to find out that he had been married.
Again, with your relationship, was there an occasion on February 15th of 2022 that this defendant, Mario Fernandez, had sex with your wife? I think her name's Maria.
My wife's name is Maria.
And do you recall that situation?
I don't recall the date. I do recall the situation, yes, sir.
And that was based on your request.
That's correct.
Did you have to convince Mr. Fernandez to do that?
I did.
So he wasn't initially willing until you kind of pestered him for a while? Is that fair?
Correct.
And you would agree that that was recorded?
Either pictures or video, yes, sir.
And so whatever the pictures or video show about the date, you would agree that that's right?
Correct.
Okay, so if it does show February 15th, 2022, you would agree?
Yes, sir.
Did you do work for Mario Fernandez, the defendant?
I did.
What was the most Mario Fernandez ever paid you at a time?
I have no idea, but it was at the most hundreds of dollars to a couple hundred.
Did he ever pay you by check?
No.
What kind of work did you do?
I had a handyman business, and he would, I guess, subcontract me would be the correct word.
Was your handyman business registered with the state of Florida?
It was.
What was the name of it?
904 Handyman LLC.
And so the $200-300 you got was paid to you in cash. I think you said that.
You're correct.
Did you do work on the Potomac address?
I did.
The Henry Tenon, do you know who that person is?
I do. Yes, sir.
And how did you meet him?
Henry was a tenant under Mario's rental property there. I had been working for a while to raise the shower head in the shower. Been there for a couple of days back and forth before I met Henry as I was departing the home the first time.
Is the reason you're raising the shower head because Mr. Tenon is
He's very tall.
5'6", whatever he is?
Very tall, yes, sir.
Okay, and that's why you were doing that.
That's correct.
Did Henry Tenon ever work for you?
No,
Did he ever work with you?
no.
I want to talk a little bit about the defendant's issues that he had with Shanna Gardner's ex-husband. Did the defendant share issues with you that he had with Jared Bridegan?
Just two that I remember.
Tell the jury about it.
Mario had mentioned that there was some tension between him and his wife Shanna when he would have headaches, and I'd invite him over because we had determined earlier that a cigarette would clear his headaches, and I had cigarettes. And he'd stop and get a beer for two of us sometimes and bring them over. We'd drink a beer while he'd smoke a cigarette, and just say that her ex had caused a lot of problem or stress between Mario and Shanna, because she was in court over the children, and as soon as court would be over, it seemed like she would be called right back into court, as if I remember that correctly. And the second was, kind of related to that, was I think it was the boy in the family had like issues with elevation, flying to New York to see a specialist that he was required to see. I think that was it. And as far as I know, that was the detention between him and Shannon, but those are the only two issues he ever spoke to me about.
Okay. And they were both related to child custody issues.
Correct.
Do you remember on January 25th of 2022 that the defendant came to your house?
No,
Would you have known what the defendant did after he left your house?
I have no idea.
And you have no memory of what y'all would have talked about?
No, none.
Did you become aware of the fact that Jared Bridegan was murdered?
Yes.
Tell the jury about that.
I heard it first on, I think it was Channel 4 News one morning or afternoon, and just in summary. Of course, I didn't know his name at the time or anything. And then sometime after that, it was a couple days or week, Mario was helping me, I believe, moving things to and from my trailer that I was working on. Big, great trailer I had, probably 10 miles from the home. And he had a pickup truck, and he would help me move things back and forth.
Who had a pickup truck?
Mario had a pickup truck. When I got in the truck one time, he had mentioned that Mr. Bridegan had been murdered or shot. And I think the words they used was, the kid's dad is dead or something to that effect. And I said, oh my God, is that the story that's on the news and everything? And he said, yeah. And that was pretty much in a nutshell, that was it. That was about the end of the conversation.
So you didn't know anything about the name Jared Bridegan. He just referred to it as Shanna's ex. Is that fair?
Correct.
And so then you were able to put two and two together because you had seen the media stories of the case.
Yes, sir.
When did you become aware of the fact that Jared Bridegan was murdered with a 12mm Glock firearm?
Never.
Even today?
You said 12mm. There's no
I'm
such
sorry,
thing
I meant
as far as I
10
know.
millimeter. I misspoke. See, you're careful. Good. Misspoke. 10mm.
10mm, not until a couple of months ago. It was mentioned by Miss Stifler, I believe. Either her or her investigator Bennett mentioned the 10mm.
But as you indicated that you purchased a Glock 10mm firearm, correct?
Correct. One of many.
I'm showing you what's been entered into evidence as State's Exhibit 191. Mr. Biggerstaff, if you could review those last two pages of State's Exhibit 191 and indicate if that's you purchasing that 10mm Glock firearm.
Without verifying the serial number or the concealed weapon permit, that seems like the purchaser of the dealer information I bought it from.
And it has your name and address.
It does have my old name and address, correct?
So it appears to be your purchase of that 10mm Glock.
Correct.
You would only be able to verify it if you had the serial number.
And my weapon, yeah, my concealed weapons.
Make sure you're speaking in the microphone.
Speak into the mic.
Yes, I'm sorry, the serial number would verify that it would be the correct.
I'm going to leave State's Exhibit 191 up here. I'm going to show you what's been entered into evidence as State's Exhibit 190. I understand that it's not the best copy. What is State's 190?
It appears to be the handwritten inventory of 20 weapons that I surrendered in 2016.
So you recognize that.
Roughly, yeah.
And who filled that out?
Myself and my son. It's his handwriting, I believe.
And if you could go to the serial number column 3 of the Glock 10mm, go down to line 7. This is going to be the Glock 40 10mm. Can you read off that serial number?
It would be B as in Bravo, B as in Bravo, G as in Golf, L as in Lima, 770.
And can you read off the serial number of the purchased firearm in States Exhibit 191, which is up at the top?
It is B as in Bravo, B as in Bravo, G as in Golf, L as in Lima, 770.
So you would agree that this is the firearm that you purchased and the firearm affidavit that you turned over to your federal probation officer.
Correct.
So what you turned over to the federal probation officer was before you were convicted, correct?
That's correct.
So you were hoping that you would get those firearms back at some point
That's what they told me, yes, sir.
until you became convicted and you knew that would never happen.
That question, I'm sorry.
That's a question.
Yeah, that's obvious.
And as you sit here today, you cannot produce that firearm.
That's correct.
Your 10mm Glock 40 firearm was functional,
Was functional?
was it?
As far as I know, it was.
It was operational?
As far as I know,
You shot it?
I did shoot it after purchasing, yes, sir.
You had ammunition for it.
I, at one time, purchased ammunition for it, yes.
In fact, you had ammunition for all of your firearms, correct?
No,
Is there a purpose?
There's a purpose in this question, yes.
No, I mean, for the leading nature.
No, I can ask it.
All right, I'll sustain it then.
Just speed. Tell the jury what ammunition you possessed.
I have no idea what the hell I possessed back then. None.
Did you possess ammunition?
I had previously possessed ammunition. I used to have a locker which ATF searched. I used to have ammunition and guns in there, yes, sir.
Is a firearm able to be fired without ammunition?
It can be dry fired without ammunition. You can't injure anybody, as far as I know, without ammunition and no weapon, if that's what you're asking.
What happened to all your ammunition?
Ammunition and all the weapons were stockpiled in 2016, and I have no idea where that crap went. None of it. Excuse my.
No, it's you don't think these things are crap, do you?
Do I think they're crap?
Yes.
No, I was irritated about the whole situation by having to surrender my weapons, sir.
You would agree that the ammunition is not contained in the inventory.
No,
So you would agree there's no documentation that we have to show that you surrendered your ammunition.
as far as I've been told, there's no documentation to show that I surrendered anything. So that would be yes, correct.
So the crap you referenced was about the charge in your conviction, not the guns or the
The
ammunition.
word crap came from the charge, yes, sir.
Because you like guns
Used to.
and you didn't want to get rid of them. Is that fair?
I did not want to get rid of them under the situation. That's correct.
And there was a point in 2022. I just want to make it clear for the jury. When was that inventory? When did you surrender all your guns?
2016.
16. And was there a point in January of 2022, specifically January 25th of 2022, that you missed your guns?
No,
Never.
no.
Stifler, can you find that search for me? You would agree that guns have value.
Yes,
Specifically, 20 firearms would have approximately how much value?
I have no idea.
Well, I mean, have some general idea.
No, I don't have a general idea. It's not my
Is
business.
it worth $5?
Sorry?
Would 20 guns be worth $5?
I have no idea.
Would it be worth $100?
I don't know. If you're asking for guns from a convicted felon, I have no idea what they cost.
No, I'm asking you, based on your knowledge and experience and lifetime of purchasing firearms, how much they cost.
I don't know.
How much did the Glock 10 millimeter cost?
I don't know that either. It should be on the receipt.
Can you give this jury any approximation of how much these things cost?
No,
You would agree that you are not a rich man.
correct.
Could you have sold these firearms?
At what time are you asking? I'm not sure what time you're.
At any time?
I could have sold them up to 2016, yes.
And even, and when, and let me be clear, in other words, before you were convicted of the crime, could you have sold them?
Before had to surrender them, I could have sold them, yes.
Okay. Even after you surrender them, do you believe you could have sold them?
No,
And why not?
well, I know better than that. I haven't been in JSO, sir, and worked on some of the things I worked on. I know how some of the systems and checks are done.
You would agree, Mr. Biggerstaff, that your son Juan. I'll ask another question. Just try to get. Who is Juan Bickerstaff?
It's my son.
And at the time, was he in law enforcement?
Yes.
And you would agree that he helped you. I'll ask the question in a different way.
I'm sorry, you said at the time, what time are you referring to?
At the time that you surrendered your firearms.
2016? I don't know that he was. I don't think he was.
Was Juan Bickerstaff a prohibited person? In other words, could he have sold your firearms had you given them to him?
Yes,
And it was Juan Biggerstaff, the person that helped you compile your inventory.
that's correct. I think he was law enforcement because of a situation where I transferred one to him in that whole stockpile.
You think you transferred him one of the 20 guns?
Yep. Yes.
And which one was that?
It was my backup JSO pistol. It was a Glock 40 millimeter.
Block 27, 40 millimeter? It was 27 the model?
I don't know the model number. I'm sure you do.
Do you know anyone else that owns a 10 millimeter?
No.
I'm showing you what's been entered into evidence. The Stakes Exhibit 197. There's not a lot of room to put it there, so I'm going to have to, I guess, take it out.
Mr. Biggerstaff, don't get too far away from the microphone.
I handed them the paper, so you can stay there.
Pardon me.
Have you reviewed that?
Yes.
And we talked about this in your deposition. Do you remember that you did search on January 26th of 2022, 10 millimeter firearms?
No, like I told you then, I searched on all kinds of things all the time. I believe I clicked on bookmarks from the look of this.
Okay. But you would agree with the record speaks for itself.
Yes.
Okay. And then showing you, did you also, I think we talked about this in your deposition, search furniture with hidden compartments?
Yes.
You remember that?
Sure. Yes.
Okay. Now, do you remember making the statement that you missed your guns?
Yes.
Okay, so you do remember making that statement.
Of course.
And I understand you might have been speculating, but that may have been one of the reasons why you were searching for Glock 10 millimeter back in January. And I was right when I said the 25th. Those were in UTC, so it was the 25th. I'm sorry, let me go back to my question.
Please.
Your missing of the guns may have been the reason why you were searching for them on January 25th of 2020.
No, I think after looking at the furniture thing, I was looking for a way to conceal my substance abuse at home.
Okay. But you would agree that the record speaks for itself about whether you were looking at firearms as well.
Mr. Mizrahi?
I don't think that's a leading question. Do you agree with that?
I'm sure I clicked on, from the look of it, I'm sure I clicked on bookmarks.
Okay. Going back to your son, do you remember Juan Biggerstaff coming to your house? We'll strike that. Well, we'll do this now. Coming to your house on December 21st of 2022.
I don't remember the date, but I remember my son coming to my house, yes.
And it was shortly before Christmas and the holidays of 2022. Do you remember that?
I was thinking it was Thanksgiving, but yes, I remember.
And do you remember talking about the case with him?
Not the case, no.
Do you now know that Juan Bickerstaff came to your house while you were wearing while he was wearing a recording device?
I knew that. Yes, I knew that.
You know that now, or you knew that then?
Well, again, based on my prior military experience and JSO experience, and not being an idiot, it was pretty obvious.
So back in December, and I understand you don't know the specific date, but back in December of 2022, you suspected that your son was wearing a recording device? Yes or
Correct.
no?
Sure.
Okay.
Yes.
Did he tell you he did?
No, sir.
And although you may have not been talking about the case, you did talk about the investigation where police officers came to your house and were asking questions about the 10 millimeter.
About weapons, and he asked in general weapons. I don't know that he asked about the 10 millimeter. He asked about where my guns were, who had them.
And what did you tell him?
A couple different things. In the beginning, I told him that I had no idea. He knew that I didn't have any idea. He kept pushing for saying they want to know where your guns are. They want to know who has them. So then I told him that somebody would get them to me by the 1st of January. And then I would make a call to ATF and tell them who had, or as soon as I knew who had them or where they were at, I would call ATF, something to that effect.
Okay, you've had the opportunity to listen to that recording.
That's correct.
And do you remember if he talked about starting to prepare for perhaps your arrest and helping his mother deal with that? You remember that's how the conversation began?
No.
Do you also remember that you told him that the only thing they cared about was the 10 millimeter?
I told him that?
Yes.
I don't remember saying that. No, sir.
And do you remember saying that it had been in your possession the entire time?
I don't recall saying that. Actually, I think that was one of the first things I said after I saw that he was pressuring me for more information.
Okay, so now you remember saying that the 10 millimeter has been in your possession the entire time.
I may have said that, yes, sir.
Was that the truth or a lie
That would have been a lie.
to your law enforcement son?
That's correct.
Do you remember discussing that you felt law enforcement was concerned because of your relationship with Mario Fernandez? Do you remember that discussion?
No.
So the first thing you said is you've had it the whole time, but then do you explain to the jury what you remember about the second conversation where you said it was going to appear at the turn of the year?
I never said that in the beginning. In the beginning, I told him I didn't know where they were.
Okay. And then you said you had it the whole time. And then you said it was.
Somewhere during the conversation, I told him that I'd had them. Then I told him that somebody else had them and that they could produce them by January 1st.
Okay, so those are the three things. First, you said you didn't know. I'm leading just to try to make it quick. Second, you said that you've had it the whole time. And then third, you said it's going to appear on January 1st.
Correct.
Did you tell your son that you were going to call law enforcement when it would reappear?
Yes.
And this conversation would have been before January 25th of 2022.
Before, no, 2022.
This would have been, excuse me, after 2022. Sorry, I said it wrong.
Okay. Yes.
Do you remember telling your son that you told law enforcement that Steve from the Georgia Hunting Club had the gun?
I'm sorry, say that again.
Do you remember telling your son that Steve from the hunting club had the gun?
No.
Do you remember apologizing to your son that you had put him in this position?
Yes.
Do you remember telling your son that you wouldn't tell him why he had to wait until January 1st to find out where that gun was?
I remember saying something when he asked me why January 1st or something along those lines. I responded. I don't know how I responded. I don't know the words I used.
Was that a fair?
No, it's not fair. I don't remember.
Would you want to listen to that wire to refresh your memory?
You can try. The wire was pretty crappy. I helped you guys pick out some of the words before. We can, if you want to.
Okay, well, we may do that at the appropriate time.
Okay.
Were you telling the truth to your son in this conversation?
Initially, yes.
And then what changed?
I wasn't telling the truth. That's what changed.
Do you remember when Detective Lamont came to your house?
No, Detective Lamont, I don't know. I'm terrible with names.
You remember when Jacksonville Beach scheduled a meeting with you and you said, what?
If you're talking about when I was working at the school, like 4 years ago, yes, yes, I remember.
Do you remember scheduling it for the next day?
No, I remember being contacted. You know, I remember they came to the house in the morning as I was leaving to go to work. And they asked me if they could come back in the afternoon. And I said yes. And then I think that afternoon they contacted me, asked me to go down to the station, which I did at nighttime in the evening. I think it was the same day. I don't think it was the next day.
Regardless, in the meantime, you met with Mario Fernandez.
No. That day? No.
In between when you were asked to meet with Jack's Beach and the time you met with him.
No.
Okay. Do you remember deleting things off of your phone in between those two events?
No, sir.
So if the records show that, they would be wrong.
I don't remember them. I delete stuff all the time, sir.
Okay. Did you ever receive a courtesy call from the defendant about Henry Tenon's arrest?
No.
No.
Not that I remember. No, sir.
Do you recall making a statement to law enforcement that Mario Fernandez contacted you and gave you a courtesy call to tell him he might get questioned?
Told me he had been questioned, that the new tenant at the home I was working on in Potomac might be questioned, and then I might be questioned as well.
Okay, so you do remember.
I remember, yes. Sir.
Okay. Who is Fred Barton?
Fred Barton was an acquaintance for at least a couple of years. Retired sergeant from Jacksonville Beach Police Department.
And your relationship back in 2016, did you have a fine relationship with him?
I don't remember 2016. I don't know how it was. I don't remember.
Do you remember your gun cabinet going over to Fred Barton's house?
No,
It never did?
I don't recall it going to Fred's house. I can't say it never did, but I don't recall it.
What happened to your gun cabinet?
I don't know. That's where the ammunition was stored and the weapons, everything, family heirlooms, the compound bow, all that stuff was there.
And that cabinet is on the porch of your house right now.
No, it's down in a landfill somewhere. After ATF inspected it, I chunked it out in trash because it was a piece of junk.
Okay, so the ATF did go to your house and see your junky gun cabinet.
That one, as well as another one I told them I had, wasn't a gun cabinet. It was just like a document safe in my closet. I showed them that one as well.
Okay, but what you put into a landfill was the cabinet that stored all your firearms and your ammunition.
Previously, yes.
And you never know where that went, how it got back to your house?
I don't think it ever left the house, sir. It had guarding tools in it.
So the inventory that you gave your probation officer listed 20 firearms. You agree with that?
No, I don't. It's 20 different weapons. They're not all firearms, I don't believe.
Fair enough. What did you do with them?
What did I do with them? I inventoried them. We stockpiled them in the living room. I think I gave them the middle finger because I was so upset about having to surrender my weapons, and I left the room and went to bed.
Okay. Where did they go?
I don't know where they went, sir.
Do you think the probation officer took them?
Probation officer or JSO, whoever picked them up.
So is it your testimony that you think the JSO or the probation officer stole your firearms?
I don't think they stole them. I believe that was part of the process, either that or U.S. Marshals. Since I was on probation and had to interact with U.S. Marshals several times.
And your son Juan was there, was he?
Previously stated, yes, sir. He was there. He helped me with inventory.
Do you think he took them?
Do I think my son took my firearms? No, I don't think he took those. Only the one that I told you about.
The Glock.
The Glock 40 millimeter, yes, sir.
So the 19, you don't believe your son took?
If that's the 10 millimeter that you're asking me about?
Asking about all 19 other things documented on that list.
Oh, the other 19 things. No, sir. My son didn't take those. I'm sure of that.
But you don't know where they are or where they went?
I had no idea where they went. I have no idea where they are. No, sir.
And did you ever go to Fred Barton's house to drop off your gun cabinet and then pick it up a week later?
No, sir.
Are you aware of your son and his law enforcement duties in Texas had a burglary into his vehicle?
I'm sorry, say that again.
Are you aware that your son, while he was a law enforcement officer, had a burglary into his vehicle?
Into his undercover vehicle. That's correct.
You were aware of that?
I have been made aware of that. Yes, sir.
And you're aware that he listed several firearms that were stolen?
No, I'm from Miss Stifler. I believe there was only one that I was told about.
Okay. Are you aware that he took more than one firearm of yours that he says you gave him?
No, I'm not aware of that.
Mr. Biggerstaff, would you get in trouble if you possessed a firearm or ammunition at this point in your life?
Yeah, that's correct. It's against the law.
Your Honor, that's all the questions I have at this particular time.
All right, let me check in with the jurors. Is everyone okay? Okay, you may proceed. Cross.
Good morning, Mr. Biggerstaff.
Good morning, Mr. Reiser.
You doing okay?
Hanging in there, sir.
You and Mr. Fernandez have had a relationship since he was in high school, correct?
Correct.
And when you were healthy, you worked out together. You said that, right?
That's correct.
And when he would go away on deployment, you weren't sending him care packages or anything like that. You weren't that close, correct?
No, sir.
And then if he came back, you guys would talk, work out, chat from time to time, correct?
Correct.
During those chats, did Mr. Fernandez ever talk nasty about his wife's ex-husband?
No,
Did he ever tell you he wanted to kill him?
no, sir.
Did he ever tell you he wanted to hurt him?
No, sir.
Did he ever seem really frustrated, like he was going to do something to him, or he was unhinged about his wife's ex-husband?
No,
Never got that impression, right?
no. The only frustration he ever shared was the tension between the two of them and over children, his new fatherhood.
And I want to ask you a question that the government didn't ask you. And if you don't understand my question, you tell me, because I'm going to try to make it as simple as possible.
Okay.
Did you ever give Mr. Fernandez a 10mm firearm?
No, sir.
Did you ever give Mr. Fernandez any firearms?
Never. No, sir.
Did you participate in the planning of the murder of Jared Bridegan?
No, sir.
Did you help Mr. Fernandez in any way?
No, sir.
Did Mr. Fernandez ever tell you he participated in the murder of Jared Bridegan?
No, sir.
Did Mr. Fernandez ever admit to you that he had anything to do with the death of Jared Bridegan?
No, sir.
You told this jury that you don't remember what happened to your firearms. Is that my understanding?
That's correct.
And you don't remember going to Fred Barton's house. Is that correct?
That's correct.
And you don't remember what firearms Juan took. In fact, what your memory is that he took one firearm.
That's correct. Yes, sir.
But didn't you hear the government ask you a lot about history?
Correct.
You know, I don't recall them asking you about an injury that happened to you in 2022.
Yeah, I'm going to object to the form of the question.
I'll sustain it.
Were you asked any questions on direct about an injury that you sustained in 2022?
No.
Okay, why don't you tell the jury what happened to you in 2022?
I had a slip and fall injury on July 21st, coming out of a Circle K gas station. I came out of a gas station with my hands full of products. On my way to my son's, and his wife had, we just came back from Key West for the weekend, celebrating my wife's 50th birthday and my son's proposal to his wife. And they were going to show us both sides of the family, the venue that they were going to do their wedding in and see if it was available. And then we were all going for pizza. I went to a Circle K gas station because I'm a horrible cigarette smoker. I had to have my cigarettes and some caffeine. While I was inside, there was a 4-foot or so laminated poster that came out of the bottom of a frame that they use on the outside of the store to announce the breakfast sandwiches and such. It slid out of the bottom of the frame. I slipped on it. I slammed backwards, injuring my head and my spine.
Did that result in you being diagnosed with a traumatic brain injury?
Yes, sir.
And was that by Dr. Emis, a neurosurgeon here in town?
Correct.
Since the time that you have been diagnosed with a traumatic brain injury, is your memory as good as it used to be?
No, sir.
Would you agree that you don't have as good a memory as the things that happened before that?
Absolutely. I'm on medication for short-term memory loss even.
Currently, right now?
Correct. Yes, sir.
And could that affect your ability to remember details from 2016 and 2017?
Absolutely. Yes, sir.
When Mr. Fernandez would pay you for work that you did, you said it was $200 or $300. That's not total, correct?
I don't recall any amounts, to be honest. I was asked to throw a figure out there.
And you would get paid per job, correct?
Correct.
So you don't know, Mr. Fernandez may have paid you thousands of dollars over the years, right?
It could have been, it should have been documented in the invoice program that I used for my company.
And fair enough, you did fall into some substance abuse issues, correct?
Correct,
So you wanted to be paid in cash, right?
correct.
Because that's how you would buy drugs on the street, right?
That's correct. Yes, sir.
You're clean and sober now.
I am a little over 3 weeks. Yes, sir.
Congratulations.
Thank you.
But during the time that Mr. Mizrahi asked you about conversations that you had with Juan Biggerstaff, were you using drugs at that time?
Yes,
You acknowledge that you bought a 10 mm firearm, correct?
correct.
It was a bear hunting gun, you said.
A bear defense gun. Yes, sir.
Did you give that gun to Mr. Fernandez?
No, sir.
Did you give that gun to anybody that you believe the intention was that it end up in Mr. Fernandez's hands?
No,
Did you give that gun to Henry Tenon?
no,
Have you ever seen that gun since law enforcement took it from you back in 2016, 17?
no, sir, I have not.
All right. So let's look for evidence that maybe you still deal in firearms. You became a convicted felon in 2017, is that right?
Correct.
And today it's 2026, August. How many times have you been arrested for being in possession of a firearm?
0.
Objection, Your Honor.
Let me see it sidebar. You may proceed.
During the course of this entire criminal investigation, law enforcement has made contact with you on a number of occasions. Is that correct?
That's correct.
They've come into your home.
That's correct.
They've searched your home.
Correct.
Did they ever find a firearm in this case?
No, sir.
Did they ever find a bullet or an ammunition in this case?
No, sir.
Have you ever been arrested as a result of this investigation for being in possession of ammunition?
No.
Have you been arrested as a result of this investigation into you still having a 10 mm? Have you been arrested for felon in possession of a firearm?
No, sir.
Okay. At some point in time in August of or all of 2022, you were still doing handyman work for Mr. Fernandez? When you could, from time to time.
I believe so. Yes, sir.
You were still fairly injured back then. Is that,
Very, yes.
your work was limited to what you could do?
Correct.
There was a time in August of 2022 where you did go to Potomac to try to do some tile work. Do you recall that?
I don't recall the time, but I recall trying to do some tile work in Potomac. Yes.
Okay. And that's when Mr. Ordway was living there?
Is that the blonde haired young man? And
White guy?
I don't know the names. Well, yeah, Caucasian male. Yeah.
And you would meet Mr. Fernandez there to sort of go what work you should do and how to do it?
No, I think it was all via phone call and text at the time.
You
I don't-
you were texting about tile work,
Correct.
correct? And maybe you just don't remember, but if there was video of you and Mr. Fernandez at Potomac, you don't suggest that couldn't be true. You just don't remember.
Correct.
Okay.
I think that was more about the drywall when he was
Other
present.
renovation projects going on.
Correct. Yes, sir. Yeah.
So, Mr. Biggerstaff, also, well, let me back up. There was evidence that Mr. Fernandez, you were a swinger, you and your wife were swingers, correct?
Correct. We were.
And Mr. Fernandez was not the only person that would sleep with your wife that you would videotape, correct?
Unfortunately, that's correct.
Did you give any of those other people a 10 mm firearm?
No, sir.
Did you give any of those people a gun?
No, sir.
Okay. Did you give Mr. Fernandez a 10 mm firearm in exchange for him sleeping with your wife?
No, sir.
Did you have to bribe him or pay him?
No.
Okay. It was just something that you wanted him to do. It was after he told you him and his wife separated and he did it, correct?
That's correct.
Okay. Any deal that you were making so that you would give him a murder weapon and he would sleep with your wife?
Absolutely not. No, sir.
And this was something that you asked other men to do as part of the lifestyle you were living,
That's
correct?
correct.
Did he owe you a favor?
No, sir.
Did you owe him a favor?
No, sir.
Is there any other way I can ask you? Did you give Mr. Fernandez a firearm in exchange for the January 25th, or I'm sorry, February 15th meeting where he came to your house?
No.
On January 25th, there's cell phone data that suggests that Mr. Fernandez came over. Is your testimony is you don't remember why he came there?
That's correct.
Did you give him a 10 mm?
No.
Did you give him any firearm?
No, sir.
So he's been to your house dozens and dozens of times, correct?
All three of my residences. Yes, sir.
Could have been talking about, or could have been having a cigarette to clear his mind, right?
That's correct.
Could have been having a cigarette to clear your mind, correct?
Correct.
Could have been just chit-chatting like he had done dozens of times, right?
Yeah, he helped me a lot with VA information to get my VA stuff started.
And if a friend came over and stopped at your house sometime 6 years ago, and there was no real purpose for it, any reason for you to remember that?
No.
And going back to the hidden furniture search, is my understanding is you were searching for hidden furniture so you could hide drugs from your wife.
Correct.
That's the only reason, right?
That's correct.
It wasn't to hide weapons from anybody, correct?
No.
And law enforcement has searched your house?
Yes, that's correct.
Has law enforcement threatened you in this case?
Yes.
How have they treated you?
At times pretty ugly.
Have they cursed at you?
Yes, sir.
People in the state attorney's office, have they cursed at you?
Yes, sir.
Do you think they treated you fairly?
No, definitely not.
They told you that they wanted you to tell the truth and they would give you immunity, correct?
That's correct.
Did you ever accept?
No,
Did you ever bring a criminal defense lawyer with you?
no,
Did you ever plead the fifth and say, I don't want to talk, I'm just not going to answer your questions?
never.
So you've gone and you've spoken to them when law enforcement came to your house, right?
Correct.
You've gone and spoke to them at their office per their request, right?
That's correct.
You sat down for an entire deposition where I asked you questions for hours, correct?
That's correct.
And you came here today to testify in this trial.
Yes, sir.
Have you ever told anyone that you gave Mr. Fernandez a 10-millimeter firearm?
No, sir, no.
They've told you they consider you a co-conspirator in this case,
That's correct.
but they just never arrested you?
That's true.
You know from being a police officer, it only takes probable cause to arrest you, right?
That's correct.
And nonetheless, with all the allegations and the threats and the cursing, they've never arrested you.
No, all the junk, nothing, no arrests.
Because you've never given Mr. Fernandez a 10-millimeter firearm, right?
That's correct.
There's no surveillance of you giving him a 10-millimeter firearm, correct?
Say again, I'm sorry.
There's no surveillance of that.
No,
When you were giving this conversation with your son Juan, was this part of what you believed the harassment was, this wire?
yes, absolutely.
And you suspected you were being recorded?
Yes,
And you told Juan that you didn't have any firearms?
that's correct.
And then he just kept pushing you and pushing you?
That's correct.
And that was at a time when you were still using drugs, correct?
That's correct.
Would you describe your mind as clear at that point in time?
No,
And your own son, you believe, is probably recording you and pestering you about a firearm that you never gave to Mr. Fernandez, right?
that's correct.
About a firearm that you hadn't seen since 2016, likely.
That's correct.
And you knew your son was law enforcement at that time, correct?
Yes, that's correct.
Did you want him to get in trouble?
Never.
Right? When you said, I apologize for getting you wrapped up in this, did you mean the fact that he's there asking you questions and likely wearing a wire?
Yes, at the holiday time, absolutely.
Okay, so you certainly weren't apologizing for getting him wrapped up in some criminal activity you were a part of, right?
No,
Do you have anything to do with the murder of Jared Bridegan?
no, sir.
Objection asked the answer here.
Well,
Wait, overruled. Go ahead.
did you have anything to do with the murder of Jared Bridegan
No, sir.
in any capacity?
No,
So Mr. Mizrahi asked you, did you said something like the weapons will show up in January. Is something to that effect? Is that right?
correct.
Did they show up in January?
No,
Did law enforcement ever come back and say, give us the 10-millimeter?
no,
Have you been in possession of any firearms since the day that Magistrate Monty Richardson ordered you to surrender your firearms?
if that's the Middle District of Florida, then that's correct. Not one single firearm since then.
And that was unfair to you because I've shown the jury that it was Magistrate Monty Richardson who signed the order making you surrender your firearms. So if
Correct.
I represent that that's in evidence.
Okay.
That's the person or the judge. Have you been in possession of guns since then?
No, sir.
Ammunition,
No,
weapons?
no, sir.
Mr. Fernandez helped bring tables and chairs to your son's wedding the day after the homicide?
I don't remember if that was him doing that or not. Have a big blank there on who helped me, but I'm assuming since you say that, the answer is yes.
Okay, so you don't dispute that he helped you.
I wouldn't dispute that. Yes, sir.
And that was the kind of stuff you did for each other. He would help you do
Correct.
things, you would help him do things, right?
Correct.
And when Mr. Fernandez told you that day that Mr. Bridegan had been murdered, did Mr. Fernandez seem nervous?
I don't know if it was that day, but when he told me, he didn't seem nervous. No,
Did he make any admissions?
no, sir.
Did you think anything of it?
No,
Did you guys talk about what firearm was used?
no, we didn't. I don't think we ever talked about it again after that day.
After the Potomac tile work project, that was, I'm going to represent to you somewhere around August of 2022, okay?
Okay.
Did you and Mr. Fernandez have a falling out over that project?
I think we ended on bad terms because of that project. Yes.
And it was because Mr. Fernandez wanted you to work on a tighter schedule than your body was allowing you to do.
That's correct.
And you thought you made that clear, like, I'll do the project, but because of my physical condition, I need to do it on my own timeline.
Right.
And then Mr. Fernandez got frustrated with you that it wasn't going as fast as he wanted it to.
Correct.
And then Mr. Fernandez took over the tile project
I don't know what happened to it after that. I didn't go back yet.
because you guys really haven't kept in touch, right?
That's correct.
So certainly you don't owe anything to Mr. Fernandez right now, right?
No, sir.
He doesn't owe anything to you right now, right?
No, sir.
Part of your fall at Circle K, did you hire a personal injury lawyer?
After, did you say?
Yeah, after you fell, did you?
Yes, I
hire-
did, unfortunately. Yes.
And was his name Randy Reap?
Correct.
Okay, so if you had searched for Randy Reap also on the day you were looking at those thumbtack, whatever you described it on Google, that's because that was your lawyer at the time?
That's correct.
Mr. Mizrahi mentioned things like you don't have a lot of money. You would agree you would search for all sorts of things you couldn't afford, correct?
That's true. Yes, sir.
Yachts, right?
Yes.
Villas in France,
Yes.
flour tortilla recipes,
Correct.
how to make the best chocolate chip cookies,
Correct.
uh, military bases in Charleston.
Yes.
You also looked at a 9mm firearm at one point, right?
Correct.
Would it fair to say you probably have looked at thousands of things on the internet?
Yes.
Because when you were injured, you weren't very mobile, were you?
I haven't been very mobile for 6 years. That's correct.
And a lot of what you do is on your phone.
That's true.
Any rhyme or reason as to sometimes what you're looking at or why you're looking at it?
No, what I'm watching on TV usually generates my searches.
And if you had looked for a 10mm at one point in time, would you agree you wouldn't have had to do that if you still owned one?
That's a true statement. Yeah.
Because you could have gone to wherever it was and looked at it if you still owned one, right?
Right.
But you didn't do that because you didn't own one, right?
Correct.
And in those particular searches, you would acknowledge that that you never searched anything to do with firearms that had anything to do with Mr. Fernandez, correct?
That's correct.
May I have one moment, Your Honor?
Yes.
Yeah. We have no further questions. Thank you.
Peter Wright?
Sure.
Mr. Biggerstaff, you mentioned that state of Florida offered you immunity. Remember that line of questioning?
Yeah, do, yes, sir.
And who was that, me?
You, correct. You and Miss Stifler, yeah.
We're both assistant state attorneys, correct?
That's as far as I know, yes, sir.
Well, your conviction, was that in state court or was that in federal?
Federal court.
Did you, in the course of this investigation, ever sit down with a federal prosecutor?
Are you asking? Okay. You may
his
proceed.
card. So did you ever meet with the federal prosecutor with regard to this case at all?
I don't know. There was at least one probable federal somebody in my home that didn't provide credentials. So I don't know who it was.
Okay, that was an ATF agent, perhaps?
I don't know.
Okay.
They were with an ATF agent, yes.
When the talk of immunity came up, it was just me and Ms. Stifler.
No.
Who else was there?
Jack's Beach homicide, police detectives, an agent from ATF, and some female, I don't know who she was.
It's your testimony that the agent from ATF was present when we discussed immunity with you?
Correct.
Okay, that's all the questions I have here.
Anything further?
No, Your Honor.
May the witness be excused. All right, Mr. Biggerstaff, you're excused.
Thank you, ma'am.
Thank you.
Thank you.
Take your time. The next witness, I'd like to take a break, or is the next witness short? Okay. Members of the jury, we're going to take 15 minutes, okay? And then we'll come back for the next witness. Can I see the lawyers at sidebar for scheduling? deadline that if you all want to object to that procedure, okay? Because I don't want that situation that happened before I thought there were no objections filed and then somebody came in there objecting. So I'm going to set aside the deadline so that you all can object if you need to. But based on her case, I don't know how many media outlets would be interested, and it's limited space back there. So I'm also amending the order to say that I need you all to let me know that you want to participate in the individual voir dire, because I don't have enough room back there. And if I don't have enough room, then I need to find another place to do it. Okay. So I'm just giving you all a heads up. So if you want to, when the order gets filed today, it's going to be filed today. If you want to transfer it to your counsel, you can, so that they know that there is a deadline for them to object. There's a notice requirement that y'all want to participate or not. Okay. So I can make arrangements to have, the only thing that I'm excluding are the videotapes, the videoing of the jurors. So it would be the same procedure, just no cameras back there. So, because they're disclosing sensitive information related to their finances and family and medical situations. Okay. You're welcome. right. Thank you. All right, both sides ready?
State's ready.
Okay, Mr. Holman. Thank you. All right, welcome back, members of the jury. Everyone may be seated. The state call its next witness.
State calls Juan Biggerstaff.
Juan Biggerstaff, please. Good morning, Mr. Biggerstaff. Walk all the way forward, please. Please raise your right hand to be sworn in.
Sir, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
All right, sir, head to your right. Watch your step. You may proceed.
May it please the court. Please state your name for the record.
Juan Biggerstaff.
What do you do for a living, sir?
I'm an independent contractor selling roofs.
How long have you been so employed?
2 months.
And what did you do? Yeah, we do some of these questions to make sure that you project your voice and things. Previous to being a contractor with roofs, what else did you do?
I was in law enforcement
How long were you in law enforcement?
about 8.5 years.
When did you resign your law enforcement position?
March of this year.
March of 2026.
Yes.
Were you under investigation at the time you resigned?
Yes.
I want to turn your attention to February of 2022. Were you employed in law enforcement in February of 2022?
Yes.
And were you living in Texas?
Yes.
And was that a suburb outside of Dallas?
No, it was in Taos.
You were in Dallas?
Yes.
In what police department did you work for?
Irving.
Which is a suburb of Dallas?
Yes.
Okay. So you're living in Dallas, but working in Irving.
Correct.
Is that where the stadium used to be, the Dallas Cowboy Stadium?
That's correct.
So, do you know a person named Mario Fernandez?
Yes.
How do you know him?
He was a family friend of ours.
And do you see him here in court?
Yes.
And could you say where he's seated and what he's wearing?
He's seated to my right. He's wearing a blue suit.
Is he the person closest to the jury or furthest from the jury?
Furthest.
May the record reflect the witnesses identified the defendant.
Yes.
Who is John Biggerstaff?
It's my father.
I want to turn your attention to when your father got in trouble with the federal government. Do you remember that?
Yes.
Were you working in law enforcement when that happened?
No.
Well, how short after when he got in trouble did you become employed with law enforcement?
I became employed with them September of 2017, so about a year.
Okay. And do you know where that was in relation to his conviction as opposed to when he was indicted?
No.
Around the same time, maybe shortly thereafter.
Yes.
At that time, obviously, you were not a prohibited person.
Correct.
And did you help your father in the preparing of the federal affidavit relinquishing his firearms?
Yes.
Tell the jury how you went about doing that.
We collected the firearms that were in the house at the time. Just went by serial number and make and model of all the firearms, and then transported them from the house day of or day after to my sister's apartment.
The jury has already seen this, but just for consistency in the evidence, showing you what's been entered into evidence of State's Exhibit 190. Is this handwritten affidavit that you and your father filled out?
Yes,
Whose handwriting is it?
mine.
And that's list 20 firearms or items that he was surrendering?
Correct.
Describe for the jury how those firearms were transported.
I took them in my vehicle, which was a Ford Focus at the time, and they were in various bags and gun cases.
And what did you do with them?
I dropped them off at my sister's house or apartment.
What is your sister's name?
Stephanie Atkinson.
And that was her name at the time,
Uh,
2016?
yes, I believe she was married in 2016.
And how long did the firearms remain at your sister's home?
Several months. They purchased a house, and at that time is when I went and picked them back up.
Bless you.
So this is, and just for the jury's orientation, this is in 2016,
2016, early 2017.
before your father was convicted of the crime.
I don't recall the actual conviction date, but I think so, yes.
And if you don't know, that's fine, but if you remember, it was while he was on pretrial release that he had to collect his gun.
Correct, yes, that's right.
And then he was convicted later in 2017.
Right.
So after the guns were in your sister's, what happened?
So when she purchased the house, she no longer wanted the firearms in their house. I went and picked them up, and I kept them with me. Separated several for myself, kept the rest in my vehicle until I left for Texas later that year.
Which guns did you keep for yourself?
There was a Smith & Wesson 9mm, a Glock 27, it's a 40 caliber, a 243 bolt action rifle, and a Benelli shotgun.
Was one of the guns that you did not keep a Glock 40 10mm firearm?
Yes,
What happened to that firearm?
that was left at Fred Barton's residence.
Explain to the jury how that occurred.
Fred Barton was a friend of my parents, and they had kind of like a gentleman's agreement to leave the guns at Fred's house when I was leaving for Texas.
And when would that have been in 2017?
Yes.
Describe for the jury who went and how the guns were transported to Mr. Barton.
So myself and my wife were in one vehicle. My parents were in my dad's truck at the time. I transported the guns in the same cases and bags that they were in, walked them inside of Fred Barton's house, and I want to say I left them in one of his closets, and then we continued west.
Are you familiar with a gun cabinet that your father owned?
Yes,
Kind of a cheap one?
don't remember. Yeah.
Do you remember if he later on kept gardening tools?
I do not know that.
Did you transport these guns in a gun cabinet?
No.
So they were just bags
Yes.
and you put them, you believe, inside of a closet?
Yes.
Did Mr. Barton inventory them in any way? Did he look at them?
Not that I recall, no.
And your father was with you when this happened?
Yes.
What happened after you dropped the firearms off at Fred Barton's house?
I drove to Texas.
When you dropped off the firearms at Fred Barton's house, did you inventory that there were 16 firearms that were dropped off?
No.
Do you know if that 10mm was dropped off?
Yes.
So you do know that for sure.
Yes.
And you kept the 4 that you've already indicated.
Correct.
I want to fast forward now to December of 2022. Was there an occasion where you became, in your law enforcement duties, wore a recording device to go speak to your father?
Yes,
And was that done pursuant to law enforcement's request?
yes,
Did that make you feel uncomfortable?
yes.
Why did you do it?
Um, I had a order from my department that I had to follow just standard operating procedures to be cooperative in criminal investigations.
So pursuant to your law enforcement career, they're like, if they ask you to do this, you should do it. And talking to your dad, I'm gonna go through some of the things that y'all talked about, but before that, did he know that you were being recorded?
I did not tell him no.
Because that would have been a violation of wearing the recording device.
Right,
It was supposed to be surreptitious or undercover.
right.
And you did you work as an undercover police officer back in Texas?
Yes,
So you were familiar with that policy.
yes,
Can't tell people that you're recording.
right.
Okay. So did you begin the conversation with telling your dad or asking your father the question that should you be preparing your mother for something that's going to happen with regard to this 10 million?
Yes.
And what did your father say?
I believe he responded no.
Did your father indicate anything about the 10 millimeter?
In regards to 10 millimeter, no, it just that the guns would show up January 1st.
Did you remember if your father told you that the authorities only care if the 10 millimeter matches the 10 millimeter involved in the murder that they were investigating?
Yes,
Do you remember your father telling you that he had the 10 millimeter the entire time?
sorry, I do not recall.
Okay, you had an opportunity to listen to The Wire before. Would you like to listen to that again?
No, it's fine. If that's what is transcribed, then yes, that's what happened.
Do you remember your father saying when they knocked, the 10 millimeter was here?
Yes,
Do you remember your father telling you that it was here and it will appear later?
Your Honor,
Just
I'm going
not
to
yet.
object.
Grounds.
Hearsay. He can't testify to what his father is telling him. He can testify to what he
Wait.
tells him. Paul.
What's your response?
It's impeachment.
I'll overrule the objection.
You remember your father telling you that the 10 millimeter firearm was here, meaning with him, and would appear, but just cannot yet.
yes,
Do you remember your father telling you that he did not know where it was at the current time?
yes,
Do you remember your father telling you that it would appear after January 1st?
yes,
Do you remember your father telling you that he did not know who had the gun, but they would appear after January 1st?
yes,
Do you remember your father telling you that he told ATF that Steve from the Georgia Hunting Club had the gun?
yes,
Do you remember telling your father telling you that he felt bad to drag you into this?
yes,
Do you remember your father promising that when that 10 millimeter reappeared, that he would turn it in?
yes,
Mr. Juan Bickerstaff, I'm just going to say your first name just to clarify from your father. You kept 4 of the firearms. How come you didn't sell the other 16?
never crossed my mind.
Could you have?
Yes,
Were those 16 other firearms, were they valuable?
yeah,
What about the ammunition?
as far as being valuable,
Well, no. Just what happened to them?
I don't know.
As you sit here today, you know what happened to that 10 millimeter Glock
No.
Did you ever go back to Fred Barton's home and take the guns out of his closet?
No.
Would you have any idea if your father did?
No.
I'm going to fast forward to June of 2023. Were you the victim of an auto theft / burglary?
Yes.
Tell the jury about it.
I had a early 2000s GMC Yukon that was a pool car, meaning it was one of the worst cars to have in the department. I had it parked outside of my residence, and I had just gotten out of training for the day. I left my belongings in the car, getting ready to go on vacation with my wife. Came back from like a 3 or 4 day vacation, saw the car was gone. Immediately contacted Dallas Police Department. And while I was on the phone with Dallas Police, I noticed that my car was stopped at the end of the street, abandoned, and several of my bags were stolen out of the car.
So the car was taken from your home, and how far away was the end of the street?
Maybe a quarter mile.
And you were able to see that, I guess, while you were on the phone?
Yes.
And what was stolen?
My department issued Glock 31, which is a 357 SIG, and my Glock 27, which is a 40 caliber, and ammo and other police paraphernalia.
When you provided the serial numbers for those firearms, did you make an error?
Yes.
Tell the jury.
So when I was waiting for Dallas Police, I referred back to that inventory and just unintentionally copied down the incorrect serial number, which happened to be for the Glock 10mm, not the Glock 27.
I understand those are on lines 7 and 8.
I believe so, yes.
I'll approach just to make sure. States Exhibit 190. Pencil is correct. It's the Glock 27 is line 6, and then the Glock 40 10mm is line 7.
Yeah, correct. Yes.
Now, you would agree that this states 190 is lined,
Yes.
and you filled it out.
Yes.
When you reported the 2 firearms that were stolen, you were aware, or were you aware, I guess is the better question, that the 10mm firearm was important to police?
Yes.
Because you had actually worn an undercover recording device to talk to your father about that 10mm.
Right.
And you were, based on your training experience, are stolen guns and reporting them accurately important.
Yes, fair.
And you would agree that you did not report it accurately.
Correct.
And the serial number that you put down was to a firearm that you knew police were very interested in locating.
Yes.
Do you know why your father would lie to you in that recorded? I agree. It's,
Rephrase that, please.
do you know of any reason why he would lie?
No.
In that recorded conversation with your father, did he also tell you things about immunity?
Yes.
What did he say?
That he didn't believe in the immunity that was offered, and he thought it was BS.
That's all the questions I have.
Cross.
Good afternoon, sir.
Hello.
Good to see you again. Congratulations.
Thank you.
Try to get you out of here pretty quickly.
Appreciate it.
Now, Mr. Biggerstaff, I'm gonna state asked you most of the questions that I'm gonna cross-examine you on, so I'm gonna just try to be brief with you. In 2016, when you wrote that inventory, that was all the firearms and any other weapons you understood your father to have. Is that correct?
Yes.
I said 2016.
Yeah,
And you actually took possession of all those firearms in like a duffel bag and in gun cases.
right.
Was not in a cabinet of any time when you delivered it.
No,
Now, I know the state asked you, just trying to get you to project your voice, asking you questions about how long you've been in Jacksonville since you left Texas. And I understood that was since March.
correct. No, I've been back since April of this year.
You resigned your position with the law enforcement office out in Texas.
Yes,
You were not fired.
correct.
And to be a law enforcement officer, you took an oath
Yes,
to uphold the laws and the Constitution.
yes,
Okay. And I believe Mr. Mizrahi asked you, I'm fast forwarding a little bit to when you wore a wire. The reason you cooperated was because that was policy of your own department.
correct,
So it would be in violation of that policy to lie to other law enforcement.
correct.
No dispute that at some point your dad owned a Glock 40 Gen 4 10 millimeter.
Right,
Okay. I think a lot of people call it like a bear defense gun,
sure.
but you're familiar with it. You've seen it before.
Yes,
And in 2016, that was one of the firearms that you put on that inventory list.
yes,
I believe it was number 7 on that list that Mr. Mizrahi just showed you.
yes.
To your knowledge, is that the last time your father saw that firearm is when you sat and completed that inventory?
To my knowledge, yes.
Have you ever seen him in possession of it again?
No,
One of the firearms you kept was the Glock 27 that was stolen out of your vehicle.
correct.
And that was item number 6 on that list, correct?
Yes,
And the jury's seen that list and they're going to take it back in evidence, but that was just handwritten right above the Glock 10.
yes,
And the state asked you about when you retrieved those firearms from your sister and then took them to Fred Barton's house, your father was with you. Or excuse me, you retrieved them from your sister, put them in your car, correct?
yes,
Kept them in your car for a number of months.
yes.
Any idea whether or not your father had any access to that car?
He did not.
And then on your way out of town, who helped you move to Texas?
My now wife and my parents.
Like driving a U-Haul truck and,
We drove my vehicle, Ford Focus, and my dad's pickup truck.
okay. And if I understood your testimony, literally on the way out of town is when you dropped those remaining firearms off at Fred Barton's house.
Correct.
You walked them inside and put them in a closet.
Yes.
Did your father go with you?
Inside the house?
Yeah, did he like go in the closet with you?
If I remember correctly, he was inside of the house already, but
Did you see him have access to those firearms?
no.
Certainly it'd be a violation of his pretrial release or his supervised release if he had been convicted at that point.
Correct.
You then drive to Texas, you become a law enforcement officer out there. I believe it was in 2018 is when you actually got into patrol. Is that accurate?
Correct.
And at that point, you're just a police officer in Texas. You would come back and forth from time to time to visit family.
Yes.
Any time coming back and forth that you ever saw those firearms?
No.
Okay. Ever see your father with a firearm?
No.
You guys ever go shooting or anything during that time period?
No.
That would also be a violation of, at that point, his supervised release.
Correct.
And you as a law enforcement officer during this time period would somewhat be required to report him if you saw him in possession of a firearm. If you saw him breaking the law while you're a police officer, you'd be required to report him under those policies that you mentioned earlier.
Yes.
Safe to assume you never reported him because you never saw him in possession of a firearm.
Correct.
In February of 2016, did you come back to Jacksonville?
Yes.
Why?
I was getting married.
Do you recall when you actually got back in town?
It was The morning or afternoon of the 16th.
Okay. Did you come to learn that that was the same date as the homicide of Mr. Bridegan?
Yes.
When you came back in town on February 16th, did anybody give you a 10 millimeter?
No.
Did you see your father on February 16th?
Yes.
Did you see him approximately around 8 or 9 o'clock that evening
Correct.
with your mother?
Yes.
And your mother doesn't drive at night, does she?
No.
Okay, so your father had to drive your mother to your sister's house that evening,
Correct.
and you saw him that evening.
Yes.
Didn't appear nervous or anything out of the ordinary?
No.
No indication anything was wrong with him?
No.
Did you see Mr. Fernandez in the days after February 16th?
Yes.
Tell the jury about how you saw him.
Mario had offered to help, or my dad asked him to help pick up some chairs and tables to set up for a rehearsal dinner.
Yep. And do you recall what date that was?
That was the 17th, I believe.
Day after you got back in town?
Yes.
Did he appear nervous or looking over his shoulder?
No, I only saw him for maybe 5-10 minutes, but no, he did not.
Otherwise, he just helped set up like you understood he had agreed to do.
Right.
How long did you stay in town?
Full week, I believe.
Did your father or anyone else give you a 10 millimeter to take back to Texas with?
No.
And then at the end of the week, you just went back to Texas?
Correct.
Continued being a law enforcement officer?
Correct.
Later that year, did you come back to Jacksonville
Yes.
in 2022?
Yes.
And at that point, had you been interviewed by the ATF?
Yes.
They interviewed you in Texas?
Yes.
Were you truthful with them?
Yes.
Did they ask you about the 10 millimeter?
Yes.
Did you tell them the same thing you've told the jury this afternoon, that you did not see the 10 millimeter?
Correct.
And did you also get interviewed by the ATF here in Jacksonville?
Yes.
Was your story the same? You had
Yes.
not seen it?
Yep.
And again, that's part of the policies in which you have to follow as a law enforcement officer, is your truthfulness with other law enforcement agencies.
Correct.
And as Mr. Mizrahi mentioned, in December of 2022, you agreed to wear actually 2 recording devices.
Yes.
One in your pocket and then one that was like a cell phone.
Right.
Okay. And these were things you were familiar with from your own law enforcement experience.
Yes.
My understanding is they maintained observation of you to make sure that you couldn't call your father to say you were on the way over there, in order to tip him off that you were wearing a wire.
I don't know that to be true.
Okay. Did you tip off your father you were wearing a wire?
No.
Didn't write any notes or anything to say, hey, Dad, I'm wearing a wire, don't say anything?
No.
Did he mention Mario Fernandez at all during your discussion with him?
Not that I recall, no.
Your dad told you a whole bunch of different things during that conversation.
Yes.
Okay. Some inconsistencies as far as so-and-so has the firearm, or I don't know where it is, or it's going to show back up.
Right.
Okay. In essence, 3 different stories about this firearm.
Yes.
Now, your father had, my understanding, a traumatic brain injury in 2020, somewhere around that time period.
Yes. Yeah.
Did you notice that he had some difficulties after that accident?
Yes.
Did you come to understand your father also had some substance abuse issues?
Yes.
Okay. That combined with the brain issues, you noticed a big difference in your father?
Yeah.
Kind of his cognitive abilities
Yes.
and his physical abilities?
Yes.
After you finished, we'll just call it that recording session in December, did you turn over that recording to law enforcement?
Yes.
Did you get an opportunity to listen to it before you gave it to them?
No.
Did you get an opportunity to listen to it when you were with them?
No.
You just went back to Texas and continue on your law enforcement?
Yeah.
State asked you in June, when you were back in Texas, your vehicle got stolen. This was your undercover vehicle?
Correct.
And the Glock 27 that was stolen, was that the one that was given to you by your father?
Yes.
With the serial number that was listed on number 6 on that handwritten inventory?
Yes.
And as you told Mr. Mizrahi, you just simply put the wrong serial number, correct?
Correct.
Did you refer to the inventory for that number?
Yes,
Okay. And you did not put it was a Glock 10mm that was stolen. You would agree with that?
correct.
And at the time you were living in Dallas.
Yes,
So you reported your stolen vehicle to the appropriate agency because you were in Dallas.
yes,
But you also notified your agency that your vehicle was stolen.
yes.
At some point, you came back to Jacksonville and you were interviewed or met with the state attorney's office again. Is that correct?
Yes,
And during that subsequent meeting, it had become clear to you that law enforcement did not believe your position on the 10mm, correct?
correct.
Someone had actually filed some sort of a complaint with your agency that they didn't believe you were being truthful.
Correct.
Ultimately, they put you on administrative duties as a result.
Yes,
No one actually found that you were being untruthful, but because of that complaint, they placed you on administrative duties.
yes,
You understood that the people sitting at this table, Ms. Stifler and Mr. Mizrahi, didn't believe you.
correct.
They said as much.
Yes,
And during one of those meetings, they actually offered you immunity in the event you wanted to tell a different story.
yes,
Did you accept that immunity?
no,
And you know what immunity is from your law enforcement experience, correct?
yes,
And whether or not that included federal authorities sitting in the room or otherwise, you were interviewed by ATF multiple times
yes,
and by state law enforcement.
yes,
Do you stand by every statement you've given to them?
yes, I do.
You told the truth every time.
Yes,
Certainly don't want to have a negative impact on your new family by being untruthful with them.
correct.
Mr. Bickerstaff, did you have any involvement in the homicide of Jared Bridegan?
No,
Do you have any reason, do you have any evidence that Mr. Fernandez had any involvement in that homicide?
no, I do not.
Do you have any involvement with disposing of a firearm?
No,
You consulted with an attorney out in Texas during your administrative duty time period?
yes, employer,
em-
employee attorney. Yeah.
It was an employment lawyer,
Yeah.
correct? Do you have any other information that would actually implicate Mario Fernandez in this homicide?
No,
I have just a moment, Your Honor.
Yes.
I said congratulations at the beginning of your testimony. It's because you had a baby last week.
yes, sir.
I noticed you had the armband on.
Yeah,
Your Honor, I don't have any further questions.
Okay. Thank you. Redirect.
Yes. Mr. Juan Bickerstaff, do you love your father, John Bickerstaff?
yes,
Do you love your mother?
yes.
That's all the questions I have, Your Honor.
May the witness be excused.
You may.
Yes, Your Honor.
Okay, thank you. All right, members of the jury, I appreciate your patience in pushing into the lunch hour. He will be the last witness before the lunch break. Please leave your notepads on your chair, follow the communication over the lunch recess, and I'll see you we'll call it 1:30. We'll come back, okay? Everyone may be seated. Is there anything that we need to take up before we take the lunch break? Okay, thank you. Court's in recess. What, there was something?
I looked at myself, I'm so ready to die, I didn't wear my bike.
Okay. All right, thanks. Thank you. Good afternoon. Both sides ready?
State's ready.
Mr. Dreiser, Mr. Hill? Okay. All right, let's bring in the jurors, please. Thank you. All right. Welcome back, members of the jury. Everyone may be seated. All right. How was lunch today? Okay, good. All right. So we are ready to continue with the evidence. State of Florida, call your next witness.
Chris Johns.
Chris Johns. Good afternoon, detective. All right. Will you please raise your right hand to be sworn in?
Detective, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
You may
please.
proceed.
Thank you, Your Honor. So jury knows you. We don't have to go through any introductions. You've been brought back primarily to discuss the financial records that you obtained during the course of your investigation. There was one thing we forgot to ask you, and that's State's Exhibit 199. Detective, have you had the occasion to go to the Potomac address, Mario Fernandez's former rental house, to see how it looks today?
Yes, I have.
I'm showing you it's been entered into evidence of State's Exhibit 199. Is that a fair and accurate depiction of how it looks today?
Yes, it is.
I think in the top left-hand corner of the picture, it says the Google Earth image is approximately March of 2025.
That's correct.
So State's Exhibit 199 would have been after Mr. Fernandez sold the home.
Yes.
True. So now we can go to some of the financial records you obtained. How do you, as an investigator, go about obtaining financial records?
Through a subpoena issued by the state attorney's office.
And when you receive those records, do you also receive an affidavit saying that these records are made in the normal course of business?
Yes.
Okay, so what we're going to do is, first of all, State's Exhibit 171. Let me give the jury an idea of how these records are contained. I've opened up State's Exhibit 171, and it should be on everyone's screen now. button, but I did. So when the jury looks at the tenant financial records, we see two different folders come up. Can you explain that to the jury what those are?
One of them is a Credit One bank credit card, and it's just the credit card statements, and I think the application information. The other folder is his PNC Bank subpoena return, which is his bank account.
Okay, if we open up the Credit One, is this what you refer to as his credit card history?
Yes, sir.
I think it's all pretty self-explanatory, so we don't need to go through that. But let's look at the PNC bank records. We see two different folders when we click on those. Is there overlap contained in those records?
Yes, there is.
Why do we have overlap?
It was just the time period that was requested on the subpoena, and so it was the return of it.
So is there any reason for the jury to spend their time on the June 1st, 2022 to December 31st, 2022 files?
No, the first folder basically covers the time period that we reviewed and then up until the time that he was arrested.
So that would be the 1/1/2022 to August 18th, 2022.
That's correct.
Okay. First thing we're going to look at is that certification. Is that what you refer to as you received from the records custodian?
Yes, sir.
Okay. The jury can see that published. So we will now go to 1/1/2022 to 8/18/2022. Do we see some redactions in these?
Yes, sir.
Is that like for things like social security numbers?
That's correct.
Okay. Of course. There it is. Of course, this Adobe looks completely different from on Adobe. There we go. So looking at page 22 of states 171, what is the jury looking at here?
This is a checking or statement for his checking account at PNC Bank.
And if we scroll down on page 22, can you, for the record and for the jury, indicate what the beginning balance and ending balance was of Henry Tenon on his bank statement for the dates of 1/7/2022 to 2/4/2022?
I believe the,
I guess let me show that for the jury. Is that 1/7/2022 to 2/4/2022, the period of the bank statement?
yes, sir.
All right, and then scrolling down to the balance summary.
The beginning balance is 52 cents and the ending balance is negative $2.38.
And how many deposits and other additions were there in the bank account?
There was a total of $250 in deposits and there were deductions in the amount of $252.90.
And we see an average monthly balance. Could you read that for the record?
The average monthly balance on the statement is negative $66.17.
And were there additional charges and fees like overdraft fees that were included?
$36 for the statement.
Did these statements also contain banking and debit card withdrawals and purchases?
Yes.
Let's go now to the period 2/5 to 3/4. And do we see that at the top of the statement on page 24?
Yes.
And then going to the balance summaries, can you again show the jury the ending balance, the deposits, and the ending balance?
The beginning balance was negative $2.38. There were $703.50 in deposits, $643.80 in deductions, giving an ending balance of $57.30.
And we also see significant overdraft fees.
There were a total of $144 in overdraft fees.
And again, we see the debit card withdrawals and purchases.
Yes, sir.
So now going from to 3/5 to 4/6 of 2022, beginning on page 26. What is the balance summaries?
The beginning balance was $57.30. The deposits were $11,518.95. Deductions were $4,601.79. You have an ending balance of $6,974.46. Bring his average monthly balance to $941.36. And there were $180 in overdraft fees.
So going to the deposits and other additions on page 27, do we see 3 significant check deposits?
Yes.
And can you put the dates and the amounts?
On 3/28, he deposited a check for $2,000. On 3/29, he deposited an additional $3,000 check. And then on April 6th, he deposited a $5,000 check.
And do these checks end up matching the business check stubs that were found in Henry Tenon's truck?
Yes.
Do we also see cash deposits?
Yes, sir.
Okay, we'll get to those in a little bit. And again, we see banking card withdrawals and purchases.
That's correct.
Do we see work that corresponds to Henry Tenon's truck on 4/4 of 2022?
Yes, sir, we do.
The discount tire, as well as advanced auto parts on 4/4. Do we see those?
Correct, yes.
So we're going to fast forward to page 39. That's not page 39. This is. Okay, we're looking at page, I guess 38 going into page 39. Do we have the pay period several months later?
Yes, July 8th through August 4th.
And what are the balances?
The beginning balance is $204.63. There were $829.84 in deposits. There were $1,336.39 in deductions, with an ending balance of negative $301.92.
And this would have been the balance shortly before Mr. Tenon's arrest.
That's correct.
So now if we would go ahead and fast forward, do these records contain the check deposits and or the deposits of cash that Mr. Tenon did?
Yes.
So turning first to page 44, what are we looking at here?
That is like a check, like an electronic check for a credit card payment.
Can look a little bit bigger.
I'm sorry, that's an Advance America payment.
I need to make it bigger. So this was paid to Advance America as from Henry Tenon. In other words, he owed them money for advances.
That's correct.
And that was the amount of $100 done on July 29th of 2022.
Correct.
And then we're going to go to page 50. A little bit smaller. What is the jury looking at on page 50?
This is a paycheck for Mr. Tenon from Monis and Pallets.
And can you state what the amount is?
$364.37.
In reviewing Mr. Tenon's bank records, were his payments from Monis and Pallets typically in this amount range?
Fairly consistent amount.
And did they also always include cents? In other words, they weren't flat numbers, like 100 or 200.
That's correct.
And will we see some of these deposits in his bank records?
Yes.
Did you give the date of January 28th of 2022?
No, it's dated January 28th, 2022.
No, that's okay. The jury can read that. And does it say in the memo what the pay period was?
Yes, the pay period is January 16th, 2022 to January 22nd, 2022.
So about $364.37 for a week's worth of work.
Yes, sir.
And do we see that corresponding deposit?
Yes, sir.
Okay, looking now at page 250, in reviewing these records, did you also notice that Mr. Tenon was making cash deposits?
Yes, sir.
Do you have any idea where that cash came from?
No, no, sir, I do not.
So looking at page 52, do you see a cash deposit February 11th of 2022 for $250?
Yes, sir, that's correct.
Remind us about when the homicide was?
It was the 16th of February.
Do we see the corresponding deposit check?
Yes, sir.
On 2/18 of 2022, do we also see a cash deposit?
Yes, sir, we do for $340.
And do we see that corresponding deposit check
Yes, sir.
or slip? Looking now at page 56, what is the date and deposit here?
It is March 14th, 2022,
And for how much?
$520.
Okay. User error. All right, if we can go to page 56, what are we looking at here?
That's a deposit ticket for $520.
And then page 58.
It's another deposit ticket for $150 on March 18th.
Then on March 28th of 2022, is this the deposit slip for the $2,000 check?
Yes, sir, it is.
And on page 60, what is that?
That is a check written to Mr. Tenon for $2,000 from First Choice Home Rentals LLC on March 28th, 2022.
And for how much?
$2,000.
And for what?
According to the memo line, it's for landscaping and clearing.
The person that writes the check puts that information.
Yes, sir.
In reviewing the records in this case, did you find any invoices from Henry Tenon charging for $2,000 worth of landscaping and clearing?
No, sir, I did not.
And who signed the check?
Mario Fernandez.
And then on the same day, there's another check on page 62. Please read it for the record.
Also from First Choice Home Rentals LLC to Mr. Tenon for $3,000. It says keeping up with the roof, also signed by Mario Fernandez.
Again, did you see any invoices corresponding to that?
No, sir.
And is that the deposit slip for the $3,000 on page 63?
Yes, sir, that's correct.
Then the next check is 4/4 of 2022 on page 64. What are we looking at here?
Also, the third check written by First Choice Home Rentals LLC, dated 4/4/2022, made out to Henry Tenon for $5,000. The memo line says Kickstarter, good luck, and it's signed by Mario Fernandez.
So for the period of time that you looked at Henry Tenon's bank records, were these payments different from the payments he received for his normal job at the pallet company?
Yes, sir.
Were they significantly more money?
Very much so.
And do we see the deposit on page 65?
Yes, sir.
And just to show the jury some of the deposits for his work at his pallet company, we're looking at page 66 is a deposit slip for two different checks.
Yes, sir, that's correct.
And do we have pictures of those checks on page 67 and then 68?
Yes, sir.
First 67, again, this is from Monison Pallets, and we talked about that non-round figure of $367.
88 cents, yes.
88 cents. And again, do we have a pay period listed there?
April 10th, 2022 to April 16th, 2022.
And then again on page 68, please put the amount, the date, and then the paper.
The check's dated 4/15/2022. It's for $483.79. And the pay period is April 3rd, 2022 to April 9th, 2022.
And then we also see some cash deposits.
Yes, sir. A cash deposit for $700 on May 11th.
Again, you don't know where that cash came from.
No, sir.
More cash deposits. Let's go ahead and go to 75. So we see, we don't have to go through each cash deposit. The jury can find that there are several cash deposits.
Yes, sir.
And then go to some more of the checks. On page 77. For the record, just put those items of information on the record.
It's a paycheck from June 10th, 2022 for $365.19. The pay period is May 29th, 2022 through June 4th, 2022.
And then page 80.
This paycheck is dated July 8th, 2022. It is for $324.93. And the pay period covered is June 26th, 2022 to July 2nd, 2022.
Now, Detective, could some of the cash deposits be situations where the legitimate work that Mr. Tenon did was deposited and taken out and then redeposited?
Yes, sir.
We just don't know where the cash came.
That's correct.
Good. We are now going to look at Mr. Fernandez and Ms. Gardner's financials. So when we opened up their financials, do we look at 3 different folders?
Yes, sir. That's correct.
And explain to the jury what the 3 folders are.
The Navy Federal return, which is, I would say, their primary banking institution. And then Mr. Fernandez had some accounts at USAA. And then there was also an account at ViStar, which I believe he might have been associated with, but I don't believe that to be his money. I believe it was his mother's.
And these 3 are going to be in States Exhibit 170. So let's look at the Navy Federal since that's the primary one that we're going to be looking at. Do we see that certification in the first Adobe file?
Yes, sir.
And I'll start with, what is Navy Federal Beached Bake 904?
That is a small cookie business that they owned.
And then do we have a Fernandez checking and savings account in the third Adobe?
Yes, sir.
We also have a First Choice Home Rental in the fourth.
Yes, sir.
And do we have a Shanna Gardner checking and savings in the fifth?
That's correct.
And then the Shanna Gardner Irrevocable Trust in the sixth.
Yes, sir.
So we'll begin first by going through the First Choice Home Rental, because we have First Choice Home Rental checks that were deposited in Henry Tenon's account that we just.
That's correct.
So page 2, what are we looking at here?
This is the membership application for Navy Federal Credit Union for the First Choice banking relationship. And it lists the 2 owners of this LLC.
And who are the 2 owners?
Mario Fernandez and Shanna Gardner.
Is there a percentage of ownership listed?
According to this application, it shows that Mario Fernandez is 60% and Shanna Gardner is 40%.
So we are going to go, and certainly all of these are in the record, so I'm only skipping things for time's sake. Page 46. This is going to be for the time period of February 1st, 2022 to February 28th, 2022.
Yes, sir.
Explain to the jury what they're looking at in the business checking and the business savings account of this LLC.
This is the statement for the period that you stated 2/1/2022 through 2/28/2022. Unlike a lot of banks, credit unions you have a main account number, and then you would have what they refer to as shares, which are just the sub accounts of your main account. In this case, you're looking at one, which is the business checking account, and then the other, which is just the business savings account.
And the previous balances and then show what's deposited.
The total previous balance was $4,206 for both accounts. The total deposits were $56,201.67. Withdrawals were $601.33, and then the ending total balance for both of those sub accounts is $59,806.61.
And then we'll see on page 47, obviously there was a lot of money deposited. Does it say on 222 and 228 where those $5,000 and $50,000 deposits came from?
I know at least the $50,000 one came from Mr. Fernandez's account.
So from his account into the LLC.
That's correct.
So we see here a transfer from checking for Courtney Thomas. What is this?
That would be a rent payment, I believe.
And do we see that reoccurring on a monthly basis?
Yes.
And is that for the Sandalwood property as opposed to the Potomac?
That's correct.
Do we have evidence in the Potomac property that rent was approximately $700?
I think it was 800, but I'm not sure.
780,
Yeah.
somewhere in that range. Do we see on page 50 that there were some legitimate payments made for the care of the Potomac home?
Yes, sir, that's correct.
And please show that to the jury.
You need sure.
Should I stop? No, I was just wondering what's going on.
Okay. Mr. Mizrahi.
So we're looking at, get the thing back. We're looking at page 50. If you could show the jury show the payment to Bueller Air.
Yes, sir. Right there on March 3rd, there's a $14,000 payment right there. And that was for Bueller Air Conditioning.
And do we also see payments for items from the Home Depot?
Yes, sir. That's correct.
Do we also see that $2,000 and $3,000 checks that correspond to the checks written to Henry Tenon?
Yes, sir.
And your review of these records was the balance of over $55,000 unusual for this LLC?
Yes, sir.
And although unusual, there was a large expenditure to Bueller Air.
Yes, sir. That's correct.
Was the amount that was deposited well in excess of the $14,000 to Bueller Air?
Yes, it was.
So we're fast forwarding to, well, going back to page 53, which is on a separate statement, do we see that $5,000 check on 4/7 made to Henry Tenon?
Yes, sir.
Am I underlining it on check 29?
Yes, sir. That's correct.
Do we also see a check 30 that was $240?
Yes, sir.
Did Mr. Tenon also deposit cash amounts in $240 increments sometimes?
Yes.
And that $5,000 that we see on 4/7, what was the memo line of that $5,000?
I believe it said Kickstarter, good luck.
Okay, going now to page 59. Do we see transfers that reduce the balance in this account directly to Mario Fernandez?
Yes, sir.
And just, I guess, point the dates out and circle them for the jury.
Looks like 5/15 or June 16th, June 23rd for 5,000, and then an additional for 5,000. And then there's another one for 500 on the 24th.
I think the $500 was a reoccurring one as payment for like his doing this work.
Yes, sir.
And then going to page 72. What are we looking at on page 72, specifically the October 14th?
There was a cash withdrawal for $10,000.
And below that, do we see a transfer to, from checking back into the account?
Yes, sir.
In reviewing all of these records, do there appear to be a lot of money moving around?
There was, yes, sir.
And in your training experience, could you figure out really a reason why all this money was moving around?
No, there was no what seemed legitimate reason for it.
Grounds.
Lack of foundation and speculation.
I'll sustain as a foundation.
But let me just ask the question, because you kind of add it on sometimes. Did you see any reason why any of this should be happening?
I'm gonna check if this is being, that's the reason.
Let me see it sidebar. You may proceed.
Thank you, Aaron. So we left off on page 72. Do we see a cash withdrawal for $10,000 and then a transfer of $5,000?
Yes, sir.
We're gonna now, do these records also contain the checks?
Yes, sir, they do.
And we're gonna start those on page 117. So explain to the jury what they're looking at on 117.
This is a check written to Tri-H Construction for $2,000.
And is there in the memo line or 4-line information?
Yes, it lists the White Horse property address, and I can't read the rest of the memo line there.
It may say
Agreement draw, I
drawn,
think.
I'm not really sure.
Agreement drawn or agreement draw, something like that.
And the White Horse is the Sandalwood address?
Yes, sir, that's correct.
And then on page 118, what are we looking at here?
Also a check to Tri-H Construction for $16,300. And it says siding repairs, and it also gives the White Horse Road address.
And both of these checks are back in well, one of them doesn't have a date on it. Maybe on the other part of the check it does. Yeah, they're both in 2021. Is that fair?
Yes, sir.
And then on page 119,
Another check to Tri-H Construction for $2,573.99. And it says for siding and electrical.
page 120,
This check is dated October 14th, 21 to Current Electrical Contractors Incorporated. It's for $317 and is also for the White Horse property. It has an invoice number there.
it has an invoice. Okay, and then on page 121,
This is the $2,000 check that we saw with Mr. Tenon's records. It says for landscaping and clearing.
page 122,
Another check written to Mr. Tenon for $3,000 and it says keeping up with the roof.
and 123.
A check dated 4/4/2022 for $5,000. It says written to Mr. Tenon and it says Kickstarter, good luck.
And do we see a check on page 124?
Yes, sir. This one was written April 5th, 2022 to JB Cornwell, I believe. $240. Dirt AS, I'm not sure.
And then on page 125.
Check written on 4/22/2022 for $7,494. Written to Current Electrical Contractors Incorporated, and it lists the Potomac address.
Page 126.
Check written on June 30th of 2022 to JB Corwell for $425. I believe
I
it's
think-
store 57.
And I think, Detective, if you look at for deposit only, it may be JB Coxwell.
Oh, sorry. Yes, JB Coxwell.
They're a contractor with an operating account.
Yes.
Page 127.
June 30th, also to JB Coxwell for $200. It says for fill dirt for the White Horse Road address.
128.
Current Electrical Contractors Incorporated for $158. And it says invoice 2864-A.
So let's look at the third one, which is Mario Enrique Fernandez's accounts. And do we see his information as well as a family member, which is his brother?
Yes, sir.
I'm fast forwarding now to page 59. What are we looking at for the statement period 4/8 of 22 to 5/27 of 22?
Yes, sir.
Is there an interesting deposit?
There is a transfer of $45,000.
So what was the beginning balance and what was the ending balance?
The previous balance or the starting balance have been $49,804.69. And the ending balance was $2,000, 15.43 cents.
We're into page 151. 4/28/22 to 5/27/22. We fast forward in those accounts on page 151, turning your attention to 813. What do we see on in 813?
There was a cash withdrawal of $2,250.
Turning now to the next page. And this is going to be page 152. And again, we're looking at a statement period now because we're jumping between different checking accounts in July of 2021. What is this?
It's a bank wire that was received for $382,894.34.
And did your investigation lead to where that came from?
That was the sale of the house that Miss Gardner owned prior to marrying Mr. Fernandez.
And we can see that that money remained in the account for some period of time.
Yes, sir.
And then turning to the next statement period, going from August to September of 21, we still have a large portion of that money remaining in that account.
Yes, sir.
Do we have large withdrawals?
Yes, sir.
And showing you page 156, do we see one of those large withdrawals on 9/13?
Yes, sir, for $150,000.
Now, during the course of your investigation, were you able to determine what Mr. Fernandez's employment was during the period of time that was relevant to your investigation?
I believe during the time that we were looking at these bank statements, he received money from the VA.
In addition to any monies he was receiving from the VA, did he have some rental properties,
Yes, sir, he did.
which I think you said totaled about less than $2,000?
I believe during the period we looked at, there was a total of $31,500 in rental payments.
Did your investigation lead to where this money is all coming from?
Most of the money that was transferred into this account would have derived from the trust,
And whose trust is that?
Miss Gardner's.
In your investigation, I think the jury's already heard that her parents were very wealthy.
Yes, sir.
Just look at a couple more of these. 176. Do we see a large withdrawal during the period of time of 1/28/22 to 2/27/22?
Yes, sir. There was a large withdrawal of $36,500.
And then page 180, which is the same period of time, 2/28/22 to 3/27/22. Do we have a large transfer to checking?
Yes, the $50,000 transfer.
Fast forwarding to page 265. I know the jury has already seen the fact that these accounts contain checks. What are we looking at on page 265?
That is a check that was written to Mr. Fernandez from Mercedes-Benz of Jacksonville for $35,000.
And did your investigation lead to what that was for?
I believe that's for the sale of the Tesla.
And finally, on page 277, where were we looking at there?
That is a check to Mario Fernandez from Shelley and Sterling Gardner for $75,000.
What was the date of that?
I believe it was 12/21.
I'll go back to it. Just for the record.
Yeah, December 21st, 2021.
And is there anything on the memo line?
No, sir.
So I want to spend just a minute on the beach baked. Is Mr. Fernandez also listed as the named person on that account?
Yes, sir, he is.
And does it list the 1511 Marsh Inlet Court address?
Yes, sir.
And does it also list Ms. Gardner as well?
Yes, it does.
So just to show the jury, are there any large amounts that are either deposited or written checks on this account?
No, they're usually fairly small amounts, less than
Right.
$1,000.
Is that consistent with what you learned about the home baked goods account, business that Ms. Gardner ran?
Yes, sir.
So just for example, on page 8, we're talking about balances that range between 500 and 1,700.
Yes, sir.
And then on page 10, 500 to 1,100.
That's correct.
All right. Now, we're going to look at the irrevocable trust. Before we go into what's contained in the bank records, did you also review the trust documents?
Yes, sir, we did.
And what did the trust documents say about Jared Bridegan?
That Miss Gardner could resume being in charge of her trust once she had no further legal entanglements with Mr. Bridegan.
We'll look at that in a minute. Hopefully here, I just went through the page now. Let's look at who was the trustee of the irrevocable, Shanna Gardner Irrevocable Trust.
Mr. Fernandez.
And do we see that here contained on page 1?
Yes.
Skip to page 25. Can you explain to the jury the statement period 7/18/21 to 8/27/21, what they're looking at?
Yes, it looks like there was one sub checking account and then 3 sub savings accounts. And the total balance or the beginning balance for the statement period would have been $181,195.93. Ending balance for the entire of the sub accounts was $179,713.46.
And the identical balances in the two savings accounts, would that correspond to the accounts that were designated for AB and LB?
Yes.
Guess we need to go to the beginning of the trust. Do we have an ending balance of 12/28/20 to 1/27 of 21?
The ending balance was $218,655.88.
Looked at page 52. What are we looking at here? First of all, let me put the dates. 4/8/28 of 2022 to 5/27 of 2022.
Yes, sir.
What are we looking at here?
The beginning balance was $251,026.15. And then the ending balance was $12,202.61.
And what happened from the 2021, early 2022 statements until April and May of 22? What had changed?
Ms. Gardner had opened up another account and I believe they were separating, so they were transferring out all the remaining assets.
Was there a need for an irrevocable trust anymore?
No.
And we see on that 5/2 transfer of $120,000.
Yes, sir.
Page 68, which is going to be September of 2022. What are we looking at?
This is the Shanna Gardner irrevocable trust statement, and it is $0.
I'm showing you what has been entered into evidence as defense exhibit number 3, subsection C, page 25. Can you read that into the record?
Furthermore, and notwithstanding the foregoing, when our daughter Shanna shall have no further legal entanglements with her ex-husband, Jared G. Bridegan, she may elect to serve as the trustee by delivering a signed and notarized document to the trustee then in office.
So we look at page 72. Do we also see a corresponding check to Shanna Gardner in the amount of $75,000 that corresponds to the date and time that Mario Fernandez received that $75,000 check?
Yes, sir.
So now I want to look at Ms. Gardner's checking and savings account. And we're going to go first, page 38. You could just explain to the jury what they're looking at for the statement period 12/20/21 to 1/19 of 2022.
She has two sub accounts, a checking and a savings, with a total previous balance of $1,245 and an ending balance of $1,120.63.
And do we see those everyday checking things that she's paying for and things like that?
Yes, sir.
And then from 1/20/22 to 2/19 of 2022, similar type balances?
Yes, sir.
And then 2/20 to 3/19, do we have similar type balances?
Yes, sir.
And then 3/20 to 4/19, similar balances?
Yes, sir.
Then 4/20 to 5/19 of 2022, What's changed?
There was a significant increase in the balances.
Can you show the deposits for the jury and say what they are?
So the previous starting balance was $3,246. And then there was a total deposits in the amount of $233,419.09. And then withdrawals of $15,511.80, giving her an ending balance of $221,147.01.
And do we see those 50, 45, and 120,000 figures in different parts of the other accounts?
Yes, sir.
Are you familiar with the $10,000 threshold?
Yes, I am.
Explain that to the jury.
If you take a cash withdrawal or do a wire in the amount of in $10,000 or more, they're required to do a currency transaction report, which basically reports to FinCEN or the Treasury Department any large movement of money.
That's all the question.
Thank you. Cross-examination?
Yes, ma'am.
Do you need a moment, Mr. Mizrahi?
Other than dropping my pen, no. Don't.
Need to take a few trips.
It's evidence. You need this?
Yeah. No,
This is your notebook.
yeah, I don't need it at the moment. Thank you, though. Okay. That one over there. Let's see. All right. Good afternoon.
Good afternoon, sir.
Good to see you again. Let's talk about a few things first globally. Shanna Gardner's family is extremely wealthy, correct?
Yes, sir.
Hundreds of millions of dollars in yearly revenue, correct?
That's what's been reported.
You have no reason to believe that's not true, right?
No, sir.
And Shanna Gardner's parents gave Miss Gardner and Mr. Fernandez money, correct?
Yes, sir.
And through your investigation, you were able to learn that it wasn't just those two $75,000 checks. They got regular and reoccurring money from the Gardner family, correct?
Yes, sir.
Yeah. So although you just talked about two checks, since the moment Mr. Fernandez married into that family, he started getting money, correct?
I can only go and report what is the time period that was reviewed, which those are the only checks that were received. But I have no reason to believe that they did not receive other funds.
They got money wired to them, correct?
Well, the wire that I saw was from the sale of the house.
No, but there was in all the records you reviewed, they got money wired from the Gardners to themselves, not just checks, correct?
I actually don't recall seeing a wire from them.
You're not suggesting to this jury that they got two checks for $75,000.
No, their lifestyle was funded by the Gardners.
All right, and let's back up a little bit. Let's back up. Jared Bridegan was married to Shanna Gardner, correct?
Yes, sir.
And he didn't work when he was married to Shanna Gardner, did he?
As it was reported, that's correct.
He lived off of the Shanna Gardner trust money, correct?
Yes.
Because you know through your investigation that the Shanna Gardner family paid their children for all sorts of reasons, educational reasons, and as part of their trust fund money, right?
Yes, sir.
Okay. And you pointed out a big transfer from the sale of the home of $382,000. Do you recall when I asked you on direct examination how much Mr. Bridegan got when Miss Gardner sold the home?
I don't recall the figure, but there was an amount he received.
About $390,000 that Mr. Jared Bridegan received, correct?
Yes.
Okay. So no different that Mr. Bridegan received hundreds of thousands of dollars via the Gardner family, right?
Correct.
Okay. So in this trust, you were able to learn that not only did Shanna Gardner get money, the Gardners also gave their other children money, correct?
Yes.
Okay, so there's no disagreement that the extremely wealthy Gardner family gave their children money, right?
No.
And did you make sure that it was clear, and I will if you didn't, the $75,000 checks dated 12/21, Shanna Gardner got 75,000, right?
75,000 went into the trust and 75,000 went into Mr. Fernandez's account.
Right, from the Gardner money.
Yes.
And the purpose of the trust was so that her money was protected, right?
Yes.
And you said that you were a financial planner here in town. You have your own business, right?
Yes.
So you certainly are aware that wealthy people give their children money, right?
Yes.
For tax reasons, right?
Various reasons.
To lower their inheritance tax, right?
There's several reasons. Yes.
Dozens of reasons why really wealthy people start trusts for their children, right?
Yes.
So let's just globally talk about a few more things. That trust document that says that Shanna Gardner can be the trustee of her own trust if she so elects, if she doesn't have any entanglements with Jared Bridegan. Does it say anything about Mario Fernandez?
No, it does not.
So in fact, if she has no entanglements with Jared Bridegan, she gets to control the trust, right?
That's correct.
Mr. Fernandez is already in control of the trust, right?
Yes.
He is the trustee, okay? Right?
Yes.
Okay. So let's now talk about what Mr. Fernandez had prior to the homicide. I'll stand here. Can you publish this? Can you zoom out? Can you see this, detective?
Yes, sir.
This would be from the same records that you were talking about from states 170, right?
Yes, sir.
Okay. This is a Navy federal account, right?
That's correct.
This is Mr. Fernandez's personal checking accounts, right?
I can't see the titling, but the top.
Okay, sorry. There we go.
Yes, sir.
Miss Gardner's not on this account, correct?
That's correct.
This is just his money. He can do whatever he wants with it, right?
Yes, sir.
And this is the month,
I believe it's on December 28th at the top. But
yeah, December 28th to January 27th. So this is before the homicide, right?
yes, sir.
Mr. Fernandez had access to $212,000, correct?
Yes, sir.
If he wanted to do anything he wanted with that money, there's no trust that dictates what he could do. That is his money, right?
I mean, I don't know what a divorce attorney would say about that, but otherwise, yes.
Well, they weren't getting divorced, right? So you're married, happily married people. You can just go and take whatever money you want out of your account, right?
Yes, sir.
You don't have to call a divorce attorney to do that. That's your right to do whatever you so choose with the money in your account, right?
That's correct.
You may come home and your partner may be a little upset with you, but certainly there's no law that he couldn't have done whatever he wanted with that money, right?
Correct.
Okay. Okay, let's go to the next month. This is Mr. Fernandez's checking account, correct?
Yes, sir.
Same, the statement I showed you before, except for this is the next month, 128 to 227, correct?
That's correct.
He still has $158,000 available to him, correct?
Yes, sir.
This is the following month, right? Same accounts.
That's correct.
This is after the homicide, 228 to 327. And he had 158,000. The ending balance was 96,000, correct?
Yes, sir.
All right. And that was his own personal checking account.
That's correct.
Now, you suggested to the jury that he transferred $50,000. You recall that?
Yes, sir.
He transferred it to himself, correct?
He transferred it to the LLC.
First Choice Home Rentals.
Yes.
So it didn't come from the Gardner Trust, right? So if it was ever suggested to this jury that Mr. Fernandez transferred $50,000 a week after the homicide from the Gardner Trust to himself, that would not be true, would it?
I think it's a mischaracterization in the way you're stating it.
No, I want to make sure it's crystal clear. If it was ever represented to this jury that Mr. Fernandez transferred $50,000 from the Shanna Gardner Irrevocable Trust 1 week after the homicide to himself, that would not be true, would it?
At least part of those assets would have come from the trust, yes.
What assets came from the trust, detective? I just showed you that Mr. Fernandez had $212,000. Then the next month he had 196,000. He had plenty of money in his own personal checking account, right?
Yes, that would have come from the trust.
We just talked about that on 12/28, he deposited $75,000 from the Gardners, right?
Yes.
That didn't come from the trust, did it?
Overall, I'm saying the amount of money that he was only making $37,000 a year.
Detective, we have to be really careful with our words.
I agree.
Money goes from the trust account to, and I'm going to walk you through it. We're not going to guess. Trust me. We're going to go through every single trust account record to see where that money went. But I'm asking you a very basic financial question. You can transfer money from the Shanna Gardner Trust to Mr. Fernandez. He could do that if he wanted to, correct?
Yes, he was the trustee.
That did not happen. That $50,000 did not come from the trust account, did it?
No, that specific transaction came from his account.
Right. And let's say on December 28th, Mr. Fernandez got $75,000. That could have come from the irrevocable trust, hypothetically, right?
Yes.
But it didn't. And this is why I want to make sure that words matter. Shanna Gardner's parents, Shelley and Sterling Gardner, wrote him a check for $75,000 at the end of the year, right?
Yes.
That's where that money came from.
The assets are commingled.
They're not.
They wrote him a $75,000 check and he did transfer $50,000 from his account.
Okay, we're really going to figure this out together. The Gardners live in Utah, right?
Yes.
And they're private wealth clients of Chase Bank, correct?
Yes.
Because you know that because it says it right on the check. $75,000. This is an example of the two checks that the Gardners gave them, right?
Yes, sir.
You're saying it was commingled, it all came from the same place. This came from a checkbook as a Chase private client from Shelley and Sterling Gardner, right?
Yes, sir.
From their bank account, right?
Yes, sir.
That did not come from the irrevocable trust, correct?
No, that check was, the check that you just showed me was deposited into the trust.
Right. And the identical check, with the exception of it saying Shanna Gardner, it said Mario Fernandez, right?
Yes.
And that came from the Chase private wealth management banking account of Sterling and Shelley Gardner, right?
Yes, sir.
So that didn't come from the irrevocable trust, right?
That specific $75,000, no, it did not.
Okay. And in addition to all the other money that Mr. Fernandez had, you're saying, well, it's all commingled. It came from the irrevocable trust. Isn't that what you're trying to say?
Yes.
Well, 35,000 of it came from Mercedes-Benz of Jacksonville when he sold his Tesla, right?
Yes.
That didn't come from the Shanna Gardner Irrevocable Trust, did it?
I mean, you would have to go back and look and see. You'd have to have a much larger picture of knowing where the Tesla was purchased from.
But the check came from Mercedes-Benz of Jacksonville, right?
For an asset that was sold to them, but we don't know how that was purchased.
You don't know. So you can't say it came from the Gardner irrevocable trust, can you?
You're correct, I can't.
Right. Because you know for sure it came from Mercedes-Benz of Jacksonville, right?
Yes,
So let's talk about two things that we know for sure. $75,000 came from the Gardners personally, not the trust account, right?
that's correct.
And 35,000 came from Mercedes-Benz, right?
Yes.
So that's $110,000 right there that we know for a fact did not come from the Gardner Trust, right?
It would depend on how the Tesla was purchased. There's no way to know that with the records that we currently have.
You're saying that whenever he bought the Tesla, when did he buy the Tesla?
I don't remember exactly when it was purchased.
So you don't even know if he was married when he bought the Tesla, do you?
Off the top of my head, no.
So you're trying to insinuate that possibly it could have come, this asset could have come from money that was given to him through the trust account for an asset that you don't even know when it was purchased, right?
I'm just saying that that is a possibility versus just saying that the Tesla was his outright. And so the money that he got from Mercedes-Benz was his and did not originate from the trust or the Gardners.
All right, well, let's circle back.
Okay.
Let's go to the trust. No. Let's go to the trust account.
Mr. Dreiser, could we take a break?
Sure.
Would that be too
No.
disruptive to you?
No, it's
I'm going to say the jury will take 15 minutes, okay?
I don't.
All right, please let the record reflect that the jury's left the courtroom. Everyone may be seated. The court will be in recess for 15 minutes, so we'll come back at 3 o'clock. Darren. Welcome back, members of the jury. Everyone may be seated. Mr. Dreiser, you can continue.
What's the number? Yeah, Shane. We're working through some bank records, trying to figure out money, correct?
Okay.
You've reviewed lots of stuff in order to make findings as to where you think money came from, right?
I don't understand the question.
You've had access to review lots of documents so you could try to get a better understanding of how the Fernandez family, the Gardner family, and the Gardner wealthy family out in Utah, how they move money. That was part of the job of you trying to figure that out, right?
Not necessarily, no.
What have you been testifying to for the last hour and a half?
I received bank statements for a specific period of time that show a picture of a certain thing, but what you're describing is much larger than what was actually done.
Okay. May I approach, Your Honor?
Yes.
I'm showing you what's been labeled and admitted in evidence as defense 2. This will help us figure out where the money came from. Do you have you know that Mr. and Mrs. Fernandez had a prenuptial agreement?
No, I've actually not seen this.
No one showed you their prenuptial agreement?
No,
So you're seeing it for the first time?
yes,
Okay, and one of the disputes that we were just trying to reconcile is whether the Mercedes-Benz money from the Tesla, you were saying, well, it could have circulated back through money that came from the trust. And I was saying, well, you don't know that. And then you answered how you answered. Do you remember that exchange?
yes,
In a premarital agreement, you've seen those through your work, right?
yes,
In premarital agreements, people put some of their assets that they owned before the marriage.
that's correct.
You're not unfamiliar with that policy, right?
That's correct.
Ah, sorry. You agree with me? This, I'm still reading from the premarital agreement, right?
Yes, sir.
And then this is where Schedule 1, Mario's separate property is. You see that?
Okay.
Do you see it? It
Yes,
says Mario's motor vehicles, correct?
yes, it does.
And what does it say that Mr. Fernandez owned before he even got into the marriage?
A Toyota Tacoma valued at $32,000 and a Tesla Model S valued at $47,000.
Okay. And the 35,000 that came from Mercedes-Benz was because he sold that Tesla S, correct?
Yes,
So now we know that that did not come from the Shanna Gardner trust or anything to do with the Gardners, because we know it was a premarital asset before he even met Ms. Gardner, correct?
yes.
I just need a moment in between. I want to keep these papers organized, Judge.
No problem.
All right. So you testified that Mr. Fernandez in the month of April moved, he had about $4,000 or $5,000 in first choice home rentals in the month of March, right?
Okay.
When you you said that.
Can I see the statement you're referring to?
Sure. It's the month before the $50,000 gets moved. It had a balance of 4, 5, 6, 7,000, right?
Somewhere around there, yes.
Okay. And then Mr. Fernandez transferred $50,000 from his own personal account into First Choice Home Rentals, right?
Yes,
But then we also know that that month he bought a $15,000 AC unit for the Potomac address from Bueller Air Conditioning, correct?
yes,
So he had to transfer money into First Choice Home Rentals or the check would have bounced, correct?
yes.
And you don't know if Mr. Fernandez knew exactly how much that AC was going to be, right?
I would imagine that there was some type of talk about price prior to, but
Maybe an estimate, right?
yes,
Right. And you don't want to bounce a check ever, right?
no,
Especially if you have plenty of money in one account, there's no reason not to move over to another account to make sure you cover your costs for that month. That's just good financial planning, isn't it?
yes,
And he also wrote Mr. Tenon $10,000 worth of checks the next month, correct?
yes,
So besides the $15,000 approximate payment to Bueller and the $10,000 that he paid to Mr. Tenon, that's $25,000 right there, right?
yes,
And then you said later he moved another two payments of $5,000 back to the original personal banking account, correct?
they were transferred back, yes.
Right. So when you said, I don't know, I can't think of a reason why he would do that, he overpaid himself from one account to another account to cover monthly expenses. He excess paid what the monthly expenses were, right?
I wouldn't characterize that, no.
How could you characterize it any different? He put $50,000 into an account and he didn't spend $50,000 that month, did he?
No, we did not.
So he overextended additional funds that weren't needed. You agree with that?
Typically, when you deposit funds from a personal account into a business account, you're making a contribution to your company and you would receive, we're getting into taxes here, but basically the basis of your company would increase. So you would keep that money the way it is,
Or you could move it back
or you could move it back.
and then you just adjust your bookkeeping for the month. That's all that is required there, right?
Yes,
You don't pay taxes monthly. So if he overpaid the account to cover expenses and then he moved the money back, he just moved it right back from where it came from, correct?
it would be unusual to do that, but yes, that's correct.
Unusual to you?
To most people who have a business and conduct different books for their business, yes.
And you know that from your training and experience as a police officer or from your financial planning?
From my financial planning and the tax firm that I own as well.
Okay. And with that information, you think that because he moved excess funds and then moved them right back to the very account, there's something suspicious about
I
that?
didn't say it was suspicious,
Oh, it's just unusual,
unusual.
but not suspicious.
Your words.
Not suspicious.
It is an unusual transaction.
That you characterize as not suspicious.
It's unusual.
Nonetheless, when you do all of the things that we're just talking about, there's a complete bank record of it, right?
Yes, there is.
Nothing is hidden because all you have to do is subpoena the bank and it showed every single one of these transactions, unusual or not, correct?
Correct.
So around the same time period, there is the Shanna Gardner irrevocable, trust, right?
Yes, sir.
This is the trust account, also from states 170,
Yes, sir. That's correct.
top left corner, the Shanna Gardner irrevocable trust.
Yes, sir.
This is prior to the homicide, 11/28 to 2/27.
Yes.
Says an ending balance of $178,000.
Yes, sir.
Identify for me anywhere in this statement. Would you like me to bring it to you?
No, that's right. I can see that.
Identify for me anywhere in this statement where Mr. Fernandez transferred one single penny to himself.
Well, that's so the balances there.
That's why I asked. You want to see the whole statement?
Sure. There are two transfers of one for 1,800, one for 1,500 that are transferred to a checking account. Unfortunately, the way that these statements are drafted, it doesn't say which account that it went into.
Okay. Except you've already told this jury that those two accounts were designated for AB and LB, the ones that you just read that from, correct? You asked, Mr. Mizrahi asked you, and you said the two sub-accounts were designated for AB and LB, correct?
I understand what you're saying. I'm just saying the statement does not show which account the money was transferred into. It just shows that there was a transfer of $1,800 and one of $1,500.
Detective, do you still stand by that the accounts that you're referring to are for LB and AB?
You're asking two different questions.
No.
Your initial question was, do I see any transfers on the statement?
No. I asked you, see any transfers, one single penny to Mr. Fernandez was my question.
And as I'm saying here, and I'll gladly show you, there are two transfers, one of 12-1 and 12-15, to a checking account. It does not state which checking account they were transferred to.
You're talking about the highlighted,
Yes,
the one, so you're acknowledging to me that you should show me, I highlighted them and sent them to you, correct?
yes, you did.
Fair enough that I probably know that they're on there.
Yeah,
May I see it? So let's show the jury so they can see. Back to the same statement, highlighted portions that I sent over to you. In that particular month, there are two transfers, 1,800 and 1,500, and you're saying that you don't know that those are for the benefit of LB and AB?
according to the document that you're showing me, it does not state the account that they were transferred into.
Any reason to believe they went to Mr. Fernandez?
I don't know where they went based upon the document you're showing me.
Okay, so as you sit here today as the lead detective in this case, you don't have any evidence that one single penny went to Mario Fernandez?
No, so that is not at all what I said.
Okay, tell the jury, what evidence do you have that one single penny went to Mario Fernandez?
Are you talking about the totality of
No.
Are you talking about the statement? Which one were you
Talking
referring
about
to?
this $1,800 and this $1,500. If it went to Mr. Fernandez, you have all of Mr. Fernandez's accounts, detective. You would know exactly if it went into Mr. Fernandez's accounts, wouldn't you?
By looking at other statements, yes.
Do you have any reason to believe that that went into Mr. Fernandez's accounts?
I don't know.
Okay, so the answer is you don't know if any money went to Mr. Fernandez, but can we at least agree if it did, it would be less than $4,000?
Based upon the one statement you're showing me, yes.
I'm talking about, yeah, one statement, just this month, right?
Yes.
Okay. This is the next month, correct?
Yes, sir.
Irrevocable trust, 1228, 127, right?
Correct.
This is the month that the balance goes up, right?
Yes, sir.
Doesn't go down, it goes up, meaning there was more deposits than withdrawals, right?
That's correct.
This is the next page. We don't have to guess why it went up. This was the month that the checking account recognized the $75,000 check that Ms. Gardner got from her parents, right?
That's correct.
Okay. May I approach, Your Honor?
Yes, you may throw out.
Can you show me on this statement, the following month, where one single penny went from this account to Mr. Fernandez?
There is not one.
Do you agree with me? This is the next month. Shanna Gardner, irrevocable trust. Can you see that?
Would you mind pulling down here for me? Yep, thank you. Yes.
128 to 227.
Yes, sir.
I haven't skipped any months, have I?
Nope.
You see the balance?
Yes, sir.
253,000?
Yes.
Assume.
Can you tell the jury if there's any evidence that Mr. Fernandez got one single penny from the irrevocable trust?
Well, there are no withdrawals. You can tell that right here.
There are no withdrawals, so
No.
you know that Mr. Fernandez did not get one single penny.
There were no withdrawals, correct?
Right. So the answer is he got zero pennies.
On that statement, that's correct.
I've shown you three statements so far. One statement, there was a $1,500 and an $1,800 withdrawal, and you don't even know where that went. That's where we're at, right?
Based upon the statement you showed me, that's correct.
Do you think that there's a part of the statement I didn't show you?
The statement does not state where the transaction went to.
Right. So you don't know. I didn't mischaracterize that, right? Right? You don't know where that $1,500 and $1,800 went, right?
Based on the statement, no. I answered the question at least 3 times.
And that's why I said you don't know. I thought you would just agree with me. So now you're at the next monthly statement, Detective. Shanna Gardner irrevocable trust,
Yes.
228 to 327. I think that's the one we just looked at. Must be a duplicate. Nope. I'm sorry, this is right. This is the month of the homicide, correct?
Hold down the statement for me a little bit.
Oh, I'm sorry, this is post the homicide. The last statement was during the homicide, correct?
Yes, sir.
All right, so we're on track. I haven't skipped anything. Shanna Gardner's irrevocable trust, 228 to 327. Can you see it?
Yes, sir.
Show the jury, please, if Mr. Fernandez got one single penny from the irrevocable trust.
There is a $1,500 transfer. There again, the statement does not indicate what checking account it was transferred into.
Okay. So if he did get a penny, it's $1,500, and you agree as you sit here, you have no idea whether he got it or anybody else in the world got it.
The statement doesn't state what checking account was transferred into.
Okay. But you have all of Mr. Fernandez's checking accounts for that exact same time period, right?
Yes, I do.
So you would be able to find out in 2 seconds if that went to Mr. Fernandez, couldn't you?
Yes.
It's the next month. Shanna Gardner irrevocable trust, 328 to 427. You agree with me?
Yes, sir.
Didn't skip a month?
No.
You please tell the jury if there's evidence that Mr. Fernandez, the month after the homicide, received one single penny from the irrevocable trust.
There was a $1,000 transfer into a checking account.
You don't know who got it, right?
Not without looking at the corresponding statements.
Even if Mr. Fernandez got every single checking transfer that you've identified, we're not even close to $50,000, are we?
No, sir.
We haven't even breached 10,000, have we?
No.
This is the irrevocable trust, irrevocable trust dated 428 to 527, correct?
Yes, sir.
And you told the jury that Mr. Fernandez and Ms. Gardner had separated at this point?
I believe so, yes.
And where did all the money go?
The money that is in the $257,000 accounts went to new accounts for the kids, just under Miss Gardner's name. And I know there's a distribution of the rest of the assets, but I couldn't tell you exactly where from the statement.
Any reason to believe that Mr. Fernandez got any of it?
I don't recall exactly how much he got.
The vast, vast majority, like hundreds of thousands of dollars, all went to Miss Gardner, correct?
Yes, sir.
Any evidence that Mr. Fernandez ever got $50,000 from the irrevocable trust
Directly?
during this time period?
No,
Certainly not a week after the homicide. We've gone through all those statements, right?
yes,
And you haven't been able to identify that Mr. Fernandez moved $50,000 from the irrevocable trust to himself 1 week after the homicide. That's for sure. You have not been able to do that as you sit here this afternoon, correct?
not based upon those statements, no.
Are there any other statements that I'm not showing you of the irrevocable trust, detective?
No,
And again, this is the following month of the irrevocable trust, 5/28 to 6/27. And now it's down to about $10,204.
yes,
All-
sorry,
And that's consistent with all the money being transferred to Ms. Gardner, correct?
yes.
It never goes back into the irrevocable trust account at Navy Federal. The money never gets back in there, correct?
No,
And it never goes to Mr. Fernandez, correct?
the statement you showed, no.
There are no statements that show the money ever going to Mr. Fernandez, correct?
No,
And you know that because you showed the jury that Miss Gardner would regularly have like $2,000, $3,000, $4,000 in her account when she was in the marriage to Mr. Fernandez, right?
yes, that's correct. It was a small amount.
Then after Mr. Bridegan died, now we're talking big money, right? Tens of thousands, hundreds of thousands of dollars got transferred from the account that Mr. Fernandez controlled to Ms. Gardner herself, right?
Yes,
And you have no evidence that Mr. Fernandez was ever on any of the accounts that Ms. Gardner set up when she moved, right?
that's correct.
And you also know that when Mr. Fernandez got arrested, okay, Ms. Gardner had about $500,000 in her bank account, correct?
Something about that, yes. So she had access, not necessarily on her account specifically, but yes, she had access to a significant amount of money.
Way more than she had when she was married to Mr. Fernandez, right?
Yes,
And Mr. Fernandez, in all of his accounts added up when he got arrested, he had about $70,000, correct?
thought it was closer to 80, but about there.
I'll give it to you, $80,000. Significantly less money that he had during the course of the marriage, correct?
That he had access to.
That he had access to, right?
Yes,
So Mr. Fernandez didn't get richer, he got poorer, right?
yes,
Because he's divorcing and separating from the Gardner family. He's no longer getting annual gifts, right?
I would not have a way of knowing that.
You do have a way of knowing it because you reviewed their bank records. He no longer got any annual gifts from the Gardners, detective, correct?
I don't know what he does and doesn't get anymore.
Okay. But you do know what went into his bank account and you know he had substantially less money at the time he got arrested, correct?
Yes,
And he was living with his brother in Orlando, nowhere near Mrs. Gardner, correct?
yes,
So now let's talk about the checks that Mr. Tenon received, right?
okay,
There were 3 of them. You agree with that?
yes, sir.
And they were checks that were at the end of March and one was in early April, right?
The checks were all given to him at the same time.
Well, they weren't cashed at the same time,
That's correct.
right? So you weren't there when the checks were exchanged, correct?
I wasn't, no.
Okay. And just because the check stubs were in his truck, you don't know that they were given to him at the same day. You're just making that assumption, correct?
It would be highly unusual that the 3 check stub would still be intact and the checks were not given to him all at the same time.
Unless, as you know, owning your own business, managing other people's businesses, that you can rip one check out, then a second check, and then when the third check comes, you just tear all three out and hand it to them. You know that's exactly what can happen, right, Detective?
I have never have seen that happen before.
Of course you haven't, but in this case, you weren't there when Mr. Fernandez ripped the checks out.
No, it was not.
And although they're on different dates, not one single one of them was cashed the same day, correct?
I think two were cash, excuse me, I apologize. Two of them were deposited the same day. I think one of them went on hold, and then the other one was deposited later.
Okay. So at that time, let's just get some perspective here. The homicide was February 16th, 2022, right?
Yes, sir.
This is a murder for hire, a solicitation. That's what the jury is trying to figure out here, right?
Yes, sir.
Okay. What evidence of checks or payments do you have that Mr. Fernandez paid Mr. Tenon in November of 2021?
I'm sorry, can you repeat the question?
Yep. What evidence of payments do you have that Mr. Fernandez paid Mr. Tenon any money in November of 2021?
There were statements made that indicated that one of them was a payment.
You have three payments in March, two payments in March and one in April. I'm asking you of November of 2021.
There was no payments made that I'm aware of.
Okay. No payments from Mr. Fernandez to Mr. Tenon in November of 2021. You agree with me?
Yes,
There are no payments that you have any evidence of between Mr. Fernandez to Mr. Tenon in December of 2021, correct?
unless there was some cash exchange, there's no evidence of that.
You don't have evidence that the cash was exchanged, do you?
No.
What evidence, and you have no evidence, that any financial transactions occurred between Mr. Fernandez and Mr. Tenon in January of 2022, correct?
That's correct.
Okay. So that's the 3 months preceding the homicide, right?
Yes,
And then there's 16 days in the month of February. You have no evidence that Mr. Fernandez paid Mr. Tenon one single nickel in the 16 days preceding the homicide, do you?
correct.
Okay, so far, you've agreed with me that Mr. Fernandez hasn't paid Mr. Tenon one single penny prior to the homicide, correct?
Unless it was a cash payment. That's
That you have no evidence of, right?
correct.
So now there's the second half of February, and you have no evidence of any payments that Mr. Fernandez gave Mr. Tenon post the homicide that month, correct?
That's correct.
Then the next month is March. In the month of March, that's when there's all sorts of media articles about this case, correct?
Yes, sir.
The blue truck is released to the media. I think you told this jury March 9th, correct?
That was a little later in March, but it was in March.
Sometime in mid-March, right?
Yes,
That's when, if you were Mr. Tenon and you owned a blue truck, you could be on notice if you were watching the news that they may be looking for you, correct?
that's correct.
And it's that same month that Mr. Fernandez writes a check to Mr. Tenon, correct?
Yes, sir.
And you would agree with me that a check has got to be the most identifiable form of payment that almost exists on planet Earth, right?
Yes, sir.
You have to write your name on it. You have to sign it. It comes from your account. It goes into the person who deposits its account. All the information we have is right there for anyone to look at when you write somebody a check, correct?
That's correct.
And then there's memo lines on the check. And the memo lines are for keeping up with the roof on one and landscaping clearing on another, correct?
That's correct.
And you know, as the chief or lead investigator in this case, that Sonny Fong, 11 months after the homicide, called Mr. Fernandez, correct?
Yes,
And in that call, he asked if he knew Mr. Tenon, and he said that he did, right?
that's correct.
He didn't deny knowing him, right?
No,
Mr. Fernandez's phone records indicate that he's having communications with Mr. Tenon in January and February and March, correct?
yes, sir.
Okay. So in the conversation, Mr. Fernandez acknowledges, I paid that guy to do some work for me, right?
I believe you made some kind of comment about him. Yes,
I mean, it'll stand for itself, but as the chief lead detective in this case, you've heard that call. It's in evidence, right?
yes, sir.
And Mr. Fernandez says, I had him do some tree work for me, right?
Correct.
That's on the memo line, right?
Yes,
He said, I had him help me with the roof, right?
Yes,
That's on the memo line, right?
yes,
No one in law enforcement has any reason to believe that Mr. Fernandez knew he was being recorded on that line, correct?
that's correct.
Everyone has spoken to Mr. Fong in this case, and he's testified. He said he had no reason to believe he was being recorded on that call, right?
That's correct.
So Mr. Fernandez would have to, 11 months after the homicide, on an unrecorded phone call, or a recorded phone call that he's unaware of, he just happens to identify exactly what he paid Mr. Tenon for via check.
I can't say why Mr. Fernandez said that.
But you do know that Mr. Tenon did legitimate work for Mr. Fernandez. Your investigation revealed that fact, didn't it?
It was stated that the work was done, yes.
At that time, in March, Mr. Fernandez had hundreds of thousands, he had access to hundreds of thousands of dollars, correct?
Yes, sir.
$5,000 isn't a great deal of money to Mr. Fernandez at that time, is it?
No, sir.
And in that period of time, he writes him a check, Kickstarter, good luck, right?
That's correct.
You learned through your investigative efforts that Mr. Tenon wanted to start his own pallet company, right?
There were some records that indicated that.
Okay, and I'm going to represent to you that it's in evidence that a week before Mr. Fernandez wrote those checks, Mr. Tenon Googled business plans. Did you know that?
I know there was some Googling of that. I don't remember the exact time frame.
Miss Day, we went through the notepad where he wrote in his business plan. We already did that exchange, right?
Yes, sir.
Okay, I'll show you the Google in a minute. I just got to find it. It's not in ours. Maybe it is. Give me 1 second. And there was no secret that Mr. Tenon wanted to start his own pallet company, right?
I don't know whether he actually wanted to start a pallet company or not.
He wasn't making a whole lot of money in the pallet business, was he?
No, it was not.
It's not uncommon that a person who isn't doing well financially would want to do better financially, is it?
No,
Mr. Tenon had decades of experience in the pallet business, correct?
I don't know specifically how much. I would say that he had some experience in the pallet business.
You went and interviewed people at Modison Pallets, didn't you? You and your team?
My team did, yes.
Yeah, and he was a good employee, wasn't he?
Yes,
And he had been there a long time.
yes,
Fair to say Mr. Tenon knew a few things about pallet work,
that's probably true.
okay? And then it just happens to be that on the poll camera footage, a pallet truck pulls up to the Potomac address and stops. We went through that exercise, didn't we?
Yes,
And then when you took photos of the Potomac address, when you guys searched it, there was stacks of pallets next to the house, weren't there?
I don't recall that. I'm not saying that there wasn't, but I don't recall it.
I'll show you pictures in a second. And Mr. Tenon's business was taking older pallets and fixing them to make them reusable. That's what he did at Modison Pallets, correct?
Yes,
I'm showing what's defendants 58 already put in evidence. Take a second to look at all the Google searches. Mr. Tenon was Googling business plans the week before he received those checks.
yes,
And then the other part of your investigation was revealed that Mr. Tenon in January, in January of 2022, Mr. Tenon didn't have a lot of money in his account. You went through that and you showed the jury that he would even have overdrawn months, correct?
yes, sir.
Okay. So that would be consistent with a person who has to go to their landlord and say, I can't afford to live here anymore, right? His bank accounts reflected that he could not afford to pay rent to Mr. Fernandez, right?
I would say the bank accounts afforded that he probably would have a hard time paying his rent.
Okay, so we agree. And that was the time that Mr. Fernandez said, again, on the Sunny phone call, I tried to work with him, but he just couldn't come up with the money, so I had to get a new tenant. So that's consistent, correct?
Yes,
Now, you know that there are ways that you can pay somebody via implied payments, meaning you don't actually pay them money, you give them value. You're aware of that, right?
Yes,
In your world, in the fancy business world that you come from, that's called sweat equity, right?
something like that, yes.
In this case, we know that Mr. Tenon was having a hard time paying rent to Mr. Fernandez, correct?
According to what Mr. Fernandez said on the call, yes.
And according to Mr. Tenon's bank records, they're consistent with that, correct?
Yes,
You told the jury that you think the rent payment was around $800 to live at the Potomac address, correct?
yes,
So if you didn't want to write checks, if you didn't want to have any cash exchanges, you could just let someone live at your house for free. And every month you'd get $800. That's another way to pay somebody, correct?
I don't understand the question.
If Mr. Fernandez wanted Mr. Tenon to do something illegal for him, he could have just said, why don't you stay in my house and don't pay me rent? And every month it'll be as if you got $800. That's another way to pay somebody, correct?
I mean, hypothetically speaking, yes, he could do, I guess he could do that.
But that didn't happen in this case. Mr. Tenon left, put his stuff in the garage, and Mr. Ordway moved in, correct?
And Mr. Tenon was still basically living there.
From time to time, but he also stayed at his girlfriend Peanut's house. You learned that during the investigation, didn't you?
He pretty much stayed at Potomac.
I showed you, and I'll do it again if I have to, but you remember when I showed you the address of what Mr. Tenon had put on the pawn shop receipts after he had moved out of Potomac?
Yes, sir.
It wasn't the Potomac address, was it?
No,
It was Peanut's address on Old Kings Avenue, correct?
yes,
Okay, so he wasn't using the Potomac address anymore after he moved out. He was using Peanut's address.
according to the one slip, yes.
Okay, now we've gone through the month of March and those checks, and then early April, there's the $5,000 check. That's the 10,000, right?
Yes,
No checks in May, correct?
no,
No checks in June, correct?
no,
No checks in July, correct?
no,
No checks in August, correct?
that's correct.
And Mr. Tenon gets arrested in August.
That's correct.
And there's not a single jail call that you're aware of that you've heard where Mr. Tenon is griping that he never got paid to kill Jared Bridegan, correct?
Correct.
So it's your theory that although you learned that he does legitimate work for Mr. Fernandez, that there's $10,000. That's what he got to kill Jared Bridegan, correct?
Yes,
But you also learned that he did tree work and landscaping at his house, right?
there were conversations of that,
And you saw it. You saw work being performed at the house, correct?
not by Mr. Tenon.
I mean, I showed you a video of him coming out and unloading boxes from his trunk, right?
Yes, there was a video of him unloading boxes.
So do you think Mr. Fernandez pays Mr. Tenon to kill somebody, and then he calls up and he's like, come outside and unload the truck of my car? Don't you think Mr. Tenon would own Mr. Fernandez at that point?
I can't speak to Mr. Tenon's mind or what he did or didn't do as far as that's concerned.
If it was represented to this jury that Mr. Tenon should be dead to them, Mr. Tenon's not dead right now, is he?
No,
He's very much alive, isn't he?
yes,
May I have a moment, Your Honor?
Yes.
And I don't know if you want to take, when I am done, I'm going to need like 2 minutes to
Okay.
repack, organize those documents. There was a $10,000 cash withdrawal from Mr. Fernandez's accounts you talked to the jury about.
Yes, sir.
And then to show that Mr. Tenon would get cash, he would deposit cash into his account, correct?
There were cash deposits into his account.
Any reason to believe there's a single transaction where Mr. Tenon deposits $10,000 worth of cash,
No, sir.
$9,000 worth of cash,
No, sir.
$8,000 worth of cash,
No, sir.
$7,000 worth of cash,
No, sir.
$6,000 worth of cash,
They were all smaller deposits under $600.
that you have no idea where they came from, correct?
No.
Mr. Tenon was a handy guy, right?
Yes,
Not making a lot of money at Modison Palace, correct?
that's correct.
So if he went around, he did odd jobs for people and got cash, that wouldn't shock you.
No,
Okay, so that's where that money could have come from, correct?
I don't know where the money came from, unfortunately.
Yeah, but you certainly don't know that it came from Mr. Fernandez, right?
Correct.
And there's no huge increase. Let's say the month that the $10,000 cash withdrawal, did you get any evidence that all of a sudden Mr. Tenon did something that was financially out of his reach, like went to Vegas for the weekend,
No, sir.
went to the Keys,
No,
took and bought himself a new car?
no,
Not a single thing that would match that a person didn't deposit cash, but all of a sudden got a huge influx of cash. You have no evidence to believe Mr. Tenon got a huge influx of cash, did you?
no.
In fact, what you do know is that Mr. Tenon owned a Ford F-150 that was blue in color, that was previously owned by his father, and he couldn't even get the timing belt fixed because he left it at Jimmy Jones's house and didn't have the money to get it fixed, correct?
That's correct.
I don't have anything further, Your Honor. I just need a minute to clean up.
Okay. Any redirect of the witness? Okay, and just give him a moment.
I will. Mr. Drysdale, I'll need defense too, please.
I passed the witness number.
Right, thank you. Mr. Mizrahi.
Detective Johns, could you explain to the jury how what they have seen is just a small snapshot of the potential financial records or financial transactions that would exist in the entire world with regard to these people?
We only collected a few months period of time that was around before and after the homicide, and it does not paint a full picture of the amount of financial benefit that someone would have received during the course of their marriage.
And are there ways that people can make financial transactions that would not appear in bank records?
Yes,
Can you hand each other things of value?
yes,
Jewelry, cash, anything else?
all kinds of things that are worth something that could be sold later that aren't going to be recorded.
The bank accounts you did receive were the bank accounts that we were able to find out about in subpoena.
Yes,
Could there be other bank accounts that we never found out about?
yes,
So it's just a small snapshot of the financial records.
that's correct.
Okay. Because the defense asked you questions about there was only the $10,000 in checks, but we also see that Mr. Tenon deposited, although not $10,000 worth of cash, hundreds and hundreds of dollars worth of cash.
Yes, that's correct.
And certainly it's possible that he did handyman jobs, and it's certainly possible that he got it from Mr. Fernandez. We just don't know.
That's correct.
The defense asked you about jail calls, and are all inmate calls recorded?
I'm not sure.
Are you aware of the fact that the jail tells the inmates if they use jail calls, that their calls are monitored and recorded?
Yes, that is true.
Okay. So if a defendant got on the jail calls after being told that they're being monitored and recorded and said, I'm upset I didn't get my payment for murder for hire, that person would be potentially confessing.
That's accurate.
During the review of all the records in this particular case, did you see any other $5,000 checks that this defendant wrote to any charitable organizations?
No, sir.
Any investments in any other Kickstarters?
No, sir.
Anything that could be classified as trying to help another person?
No, sir.
You saw payments to himself and to his business interests.
Correct.
Defense asked you lots of questions about whether or not the defendant got any money from the trust account. But the defendant, did he get money directly from the Gardners, meaning parents, his in-laws?
Yes,
And that was, we know, at least $75,000 because we saw that check.
that's correct.
Okay. He also got over $300,000 from the marital home.
Yes, sir.
That's a lot of money.
It is.
Let's go over with what the defense counsel spent a lot of time discussing was a prenuptial agreement. Do you remember that?
Yes, sir.
What is the title of this agreement?
It is a post-nuptial agreement.
Not pre,
Correct.
post.
Yes.
What's the date that the parties were married?
I actually don't remember the exact date. They're very,
Oh, it's on there.
oh, sorry. April 13th, 2018.
April 13th, 2018. Let's look at page 12. The execution of that document,
October 15th, 2019.
that's way after their marriage date.
Yes, sir.
Do we have any idea what cars were transferred in the first 18 months of that agreement, or 14 months, 16 months?
No, sir.
Could have been the Tesla.
It could have.
Mario's bank accounts. Can you read those into the records that was written in the post-nuptial agreement?
USAA $1,463.37. And then two Navy federal accounts, one for $3,552.32. And the other for 4,000, it's either a 3 or an 8, 44.22.
And then back to that page 1 of defense 2. Can you read into record the incomes of Mario Enrique Fernandez and Shanna Gardner?
Mario Fernandez is indicated that he's self-employed and makes approximately $28,000 a year. And Shanna Gardner also indicates that she's self-employed and makes approximately $36,000 a year.
I think you explained this, but I want to give you an opportunity to make it more clear. Why, in your opinion, did Mr. Tenon receive the 3 checks on the same day, even though he deposited them on separate days?
My objection is to improper fee.
Okay.
I think this is directly in response to cross-examination questions.
Respond to the objection. Now. What's the foundation for the opinion?
Well, he crossed him on whether or not it was the same day. He crossed him. I mean, he crossed him on this.
I'll allow you to rephrase then.
Explain to this jury how the check stubs were recovered in Henry Tenon's Fiat truck.
The check stubs were, or the checks in general are a business style printed page check. There's 3 checks to a page typically, and there's stubs. The stubs were found intact inside Mr. Tenon's truck.
And those have been made in evidence, so the jury will get to see it. We talked a little bit on cross-examination about the surreptitious phone call between this defendant and Mr. Fung.
Yes, sir.
And nowhere in that call does the defendant indicate that he gave $5,000 to Henry Tenon as a Kickstarter.
No, sir.
That's not mentioned.
No.
That's all the questions I have.
Anything further for this witness?
Is that okay, Your Honor?
Okay.
In that postnuptial agreement, Mr. Fernandez, it was stated that he made $36,000 a year when they signed that postnuptial agreement. Is that correct?
28,000.
28,000?
Yes, sir.
You agree with me? That would be $28,000 more than Jared Bridegan made during the course of his marriage to Shanna Gardner, correct?
Okay. I'll sustain it.
No further questions?
Do you want to be heard? I'll hear it sidebar.
Okay, thank you.
Wait, one moment. So just for the record, I'm allowing Mr. Dreisler to rephrase his question. Go ahead.
In the postnuptial agreement, Mr. Fernandez did in fact have an income, correct?
Yes, sir.
And when Jared Bridegan was married to Miss Gardner, he did not have an income, correct?
I'm not aware of any jobs he did or didn't work.
You already answered my question earlier. You said you knew that he did not work when he was married to Miss Gardner.
I know that the Gardners provided income and education expenses for their children and their spouses.
Thank you. No further questions.
All right, may the witness be excused, or you want to?
I have to ask one more
Okay,
question.
go ahead.
Were you aware that Mr. Bridegan was in school during the marriage and learning?
Yes, sir.
That's all the question.
May the witness be excused.
Yes.
No recall?
Oh, he is subject to recall.
Okay. Stay in contact with the lawyers.
Yes, ma'am. Didn't say it.
You can call your next witness.
Your Honor, the state rests.
All right. Members of the jury, the state of Florida has rested its case. That's going to require me to have a meeting with the attorneys outside of your presence. And right now, we'll call it 4 o'clock. So we're going to recess for your purposes for the evening, okay? We will come back tomorrow again at 9 a.m., all right? So leave your notepads on your chair, please, and follow the communication rules. Have a nice evening. All right, everyone may be seated. Please let the record reflect that the jury's left the courtroom. Mr. Dreiser.
Your Honor.
Oh, Mr. Hill, sorry.
Good afternoon. Your Honor, on behalf of Mr. Fernandez, number one, we would renew all previously filed motions with no additional argument to those motions, but this time we would be making motions to count 1 and count 2 for a judgment of acquittal. If I may, I'll take a few minutes with these. As the court is well aware, judgment of acquittal is pursuant to Rule 3.380. If the close of the evidence for the state or at the close of all evidence in the case, the court is of the opinion that the evidence is insufficient to warrant a conviction, it may, on the motion of the prosecution or the defendant, enter a judgment of acquittal. And as the state is well, the court is well aware that standard changed in 2020 pursuant to Bush v. State 295, Southern 3rd, 179 out of the Florida Supreme Court. Whether the state presented competent, substantial evidence from which a rational trier of fact could find the existence of the elements of the crime beyond a reasonable doubt, viewing the evidence in the light most favorable to the state. So I want to start with count 2, the solicitation, Your Honor. The state is required to prove the defendant commanded, encouraged, hired, or requested another person, in this case, Henry Tenon, specifically from November 1st of 2021 to February 16th of 2022, requested Henry Tenon with the present intent that the other person actually carry out the offense. As the state has in their case, it's not necessary for the defendant, Mr. Fernandez, to do anything in furtherance of the offense. However, to solicit means to ask earnestly or to induce another person to engage in that contact. So the definition of earnestly means a serious manner, not lightly, casually, or flippantly. The statute requires, there is no affirmative defense that we have alleged. However, it does require an affirmative communicative act, a command, encouragement, hiring, or request directed at another person. I would point out that the state has not submitted any evidence to the jury of that affirmative communicative act. There's been no testimony that Mr. Fernandez has said a word of encouragement, a text message, an email, or any other act that would actually support that he solicited Henry Tenon. And I'd point to several different cases that specifically are on point, which is in order to show the present intent, and that would be the Florida Bar versus Marable, 645 Southern 2nd, 438.
Slow down. 645 Southern 2nd.
Yep, and I'm going to email those cases to you at this moment, Your Honor, as well as to the state. in that sense, so you'll have electronic copy
Okay.
of all case law. Bear with me, Your Honor, I'll give you that exact citation. That was 645 Southern 2nd, 438, 1994. And it was Marable, M-A-R-A-B-L-E, which establishes that present intent is required, meaning that Mr. Fernandez would have to have the present intent in addition to the solicitation and the communicative act in order to be found guilty and sustain a conviction for solicitation to commit a capital felony. In addition, Palumco, P-U-M-B-L-A-N-C-O, v. State, which is 111 Southern 3rd, 249 out of the 5th DCA, and that was 2013. In addition, State v. Gaines, 431 Southern 2nd, 736, 4th DCA, 1983. That actually established what's considered the Gaines standard. In order to support, there has to be a present intent. In that case, a particular person, their conviction was overturned when they expressed a desire for this to happen in the future, but they did not actually formalize that solicitation. And the court found that that person did not have the present intent for the crime to actually have occurred. Additionally, Your Honor, Jones v. State, 908 Southern 2nd, 615 out of the 4th DCA, which is 2005, requires guilty knowledge or mens rea on behalf of the defendant. I would just point out that there's been no witness who has testified, number one, of any evidence of the actual earnestly requested solicitation by Mr. Fernandez to Henry Tenon during the time period alleged, and simply having that relationship in and of itself with Mr. Tenon is found to be insufficient to sustain that conviction. There's no evidence of encouragement. There's no evidence that Mario Fernandez hired Henry Tenon to commit this homicide. Even in the light most favorable to the state, the checks that have been presented by way of Detective Johns and Miss Lindsay Butler are post the time period of which the state has charged Mr. Fernandez. There's been no testimony that those were actually for the homicide. There's been evidence submitted that Mr. Tenon completed legitimate work by way of the recorded phone call and the poll cameras that are in evidence as well. Additionally, with regards to count 1, as a principle, murder in the first degree, there again has been no evidence of the intent. There has to be a communicative act to show that Mr. Fernandez had an intent for this crime to occur. Having a not positive relationship, if the state were to rely on the interview of Mr. Fernandez, where he clearly states that him and Mr. Bridegan didn't have the best relationship, that in and of itself is not sufficient evidence to submit to the jury that Mr. Fernandez had the intent that Jared Bridegan be murdered. Additionally, the second element, as a principle, that the defendant did some act or said something, again, a communicative act, or did some act that was intended to and did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. There has been no evidence at all to establish Mr. Fernandez's intent. Nothing to be submitted to this jury, either for the solicitation or for the murder in first degree as a principle. As the state conceded, Henry Tenon is who they believe to have actually committed the homicide, not Mr. Fernandez. That is why they have submitted the principal instruction. Again, simply having that relationship with Mr. Tenon does not carry the day. With regards to element 2, we have heard no evidence of any incitement, cause, encourage, assist, or advise the other person to actually commit the crime. And I would draw the court's attention to a case that's so close to being on point. It's in essence a man killing the husband of the woman he was having an affair, and that's Williams v. State, 314 Southern 3rd, 775. That is a first DCA case from 2021. That proof of a relationship alone with the perpetrator is not enough. There must be proof of some overt act or words uttered in furtherance of the scheme that led to the murder, and where no such evidence exists, a motion for judgment of acquittal must be granted. Under Penny v. State, which is 421 Southern 3rd, 476, out of the 2nd DCA of 2025, in order to be a principal in a crime, one must have a conscious intent that the crime be done and do some act or say some word which was intended to and does incite, cause, encourage, assist, or advise another person to actually commit the crime. The one other point I would establish is that v. Coxwell v. State, 397 Southern 2nd, 335, 1981, establishes that both the principle for first-degree murder and solicitation both require the same communicative act in order to establish the intent, as well as with count 2, the actual solicitation. This means that solicitation charges and the principal liability charge both require the same proof of the communicative act, the act of counsel, procurement, or instigation. Where the state has submitted no evidence of that act, both charges fail simultaneously. The absence of any evidence of the communicative act, therefore, is fatal to both the solicitation charge as well as the principal liability charge. There's been no evidence submitted. I would argue contrary evidence that Mr. Fernandez had any motive to commit this crime, much less any intent that was submitted into evidence. There has been no testimony whatsoever to establish the intent element, certainly no evidence of communications that support the intent or an overt act. And mere association with or proximity to the perpetrator is insufficient to establish principle. Applies to both murder as well as, by principle and solicitation. In every Florida case, a solicitation conviction has been sustained. There has been some form of evidence of the communicative act. Draw the court's attention to Castro v. State, 939 Southern 2nd, 306, 4th DCA 2006, where an ex-husband sought to have the ex-wife murdered by a hitman. The defendant communicated with an undercover FBI agent, recorded conversations, communicating desire and intent to have the ex-wife killed. Robinson v. State, 267 Southern 3rd, 567 1st DCA 2019. Defendant clearly and repeatedly expressed present intent to commit first-degree murder. Hudson v. State, 368 Southern 3rd, 70 1st DCA 2019. Jail phone recordings providing victim's address to gang members and relief the victim had died. Those 3 cases are where the convictions had been sustained because of the communicative act that was recorded or ultimately testified to.
I might be familiar with the Hudson case.
That might have been your case. I didn't see that in the photos. You won't have to read that one.
Okay.
By contrast, there has been no evidence of any communicative act by the defendant to Henry Tenon, who is charged in this case as far as the solicitation. There has been no evidence that Mr. Fernandez asked earnestly as required by the statute. No competent substantial evidence. Maybe evidence that the defendant learned after the murder, but no evidence of prior knowledge or conscious intent. And one further argument, Your Honor, is that the state is prevented from inference stacking. The state is seeking to simply stack inferences and may get up and argue that this is somehow putting pieces of a puzzle together by way of circumstantial evidence. However, the Florida Supreme Court ruled in Baugh v. State, 961 Southern 2nd, 198 in 2007, its well-established evidentiary principle bars a criminal conviction when the fact finder must draw an inference from another inference rather than from admitted evidence, and it remains in place even after the JOA standard was changed by Bush v. State. This is not assembling pieces of a puzzle via circumstantial evidence, Your Honor. Based upon that argument in the case law, we would move for a judgment of acquittal on count 1 and count 2.
Okay. Can you give me just a moment? I'm trying to catch up. Did you send that? You sent it to my judicial assistant?
I did, Your Honor.
Can you send it to me?
I can.
Thanks. The Williams case, that's the duck hunting case.
Your Honor, admittedly, I don't have your email address, but your JA just indicated she received it.
Okay.
I'll ask her
Well,
for
I
it.
don't know. Well, she'll send it then. Thank you. Okay, I'm ready to hear from the state.
Yes, Your Honor, I appreciate the defense counsel bringing up the new standard in Bush because they spent the vast majority of their argument speaking about direct evidence that's required to prove a particular crime. Obviously, the state has put forth a substantial amount of circumstantial evidence that proves this defendant is guilty of both charges. It begins with 1,000 different facts that distinguish it from the Williams case, including that the Williams case specifically had a co-defendant that specifically provided testimony, essentially exculpating the defendant by saying, well, she didn't really help me plan the murder. We did talk about it, but I did it on my own. In this particular case, the only link between the stipulated shooter and the victim is this defendant. It's his tenant. This defendant had a motive that we spent a lot of time putting forth evidence of. This defendant had access to the 10mm firearm that was eventually potentially used in this case. This defendant had a consciousness of guilt after the fact by deleting text messages and resetting his phone so things could not be discovered. This defendant's tenant went on a dry run all the way to the victim's home, all the way to the crime scene, and then back to the rental home where this defendant was. This defendant paid the stipulated shooter for what a reasonable juror could believe was payment for the homicide. Again, doesn't require specific direct evidence of the payment, merely that a rational finder of fact could find that that was paid for the homicide in context of all the payments made to all his different business ventures and those phone records, in those financial records. The outlier of Henry Tenon's $10,000 is stark and shocking. And a reasonable trier of fact could see that that was payment for the homicide. So in the totality of all the evidence, it's very distinguishable from Williams. There is competent, substantial evidence in multiple different arenas that this defendant was the link, the hub of all the spokes that ended up with this victim dead. And if the court has any specific questions or any specific things we need to talk about, I can certainly answer those questions, but I think there is competent, substantial evidence. And I'll point out that the solicitation in all those cases, the act itself didn't happen. You're just talking about to an undercover police officer. So you have the solicitation going on. Here, the act happened. So you don't have to worry about whether or not there was an earnest ask, since the earnest ask ended up in the victim's murder.
So the defense points out that there's a lack of evidence related to even viewing the evidence in the light most favorable to the state of any communication between for the solicitation. I
Sure.
can go down the elements, but
Well, the communication, certainly the evidence is that he paid for it. And in addition, Your Honor, this defendant had substantial contact with the tenant in the months and days leading up to this crime and after the crime. Those contacts were deleted by both parties on their phones. There is no requirement in the law that we use one co-defendant against another co-defendant as long as there's substantial competent evidence to show that the agreement happened. Your Honor knows the agreement happened, the solicitation happened, because the victim was killed by his tenant with no link to the victim. So remember, the solicitation in a lot of those cases about the communication has to deal with situations where the ultimate act did not occur.
okay, so I'm going back to the elements. It's commanded, comma, encouraged, comma, hired, comma, requested. And then,
And the only reasonable, in the state's mind, in the light most favorable to us, which is what the standard is, the only way to view the evidence that we presented is this defendant hired Henry Tenon to do this.
okay. Give me just a second. So that Williams case is a little dense. They go through a lot of
It's really
legis-
dense, and it took me.
legislative history, but really what it comes down to, where the first district found that the trial court erred is that, like Mr. Mizrahi pointed out, there wasn't any, well, or actually the flip co-defendant flipped back and said that there was basically this person, Denise, did not do anything. Additionally, there was talk prior to which they found the trial court did not err in not, well, basically letting the case go to the jury on the conspiracy, just the other two crimes.
Your Honor, I would just point out the Williams case was specific to the principal theory.
Of first degree murder.
Correct.
Correct.
And I didn't know if you were
And
speaking
no,
to the,
so there were a lot of things at play. There was conspiracy, there was first degree murder. The principal theory, it was related to that because they were saying assist, advise, encourage, and they were going through the legislative history of the words aid and abet, and they were going through, that's the part that's dense a little bit. But ultimately, if you get to the meat of the opinion where trial courts need to be aware is that, let me go back up. So in that case, which Mr. Mizrahi points out, it says while, and I'm reading pages 787. It says, while Brian characterized the planning of the murder as very mutual, he also stated that he planned a lot of it and that he instigated a lot of it. And Brian never testified about anything Denise did or said to incite or encourage him to commit the murder. It's very different, I guess, factually, which is what Mr. Mizrahi was pointing out, that you had someone that was at one degree/level. And I think that's where the appellate court was drawing the line, saying that Denise Williams was culpable, her conduct was culpable based on words when it related to the conspiracy, but not because of this Brian witness. He delineated that he was the main factor, therefore making the evidence not competent or substantial enough to go to the jury. That is the way that I read that. So in this case, while I hear the defense say, and your theories are based on all of the cross-examination that you did, the state of Florida is allowed, if legally sufficient, to go to the jury based on the evidence. And I am familiar with the inference stacking, but there has to also be basically the court has to be careful between that prohibition by law and what is legally permissible related to circumstantial evidence. And so I believe that the evidence that this court has seen through the testimony of the witnesses viewed in the light most favorable to the non-moving party, which is the state, is sufficient to go forward. So I'll deny the motion for judgment of acquittal.
was that to
On
both
both
counts? Your Honor?
counts, on both counts.
Understood.
So let's have a conversation about what's going to go on tomorrow. You're going to have your witnesses available and ready at 9 a.m., if any.
Yes, Your Honor.
Then what,
I would expect it to be an extremely light day. I think you've given me latitude that that's happens. We can work on our closes and close Wednesday.
yes. So what I would like to do is, depending on the hour and time, we will finish the defense case. Is there anything left unmoved in, or everything's in from your perspective?
Everything's in from our perspective at this point.
Okay. We will do that. We will have the charge conference, as I've previously indicated. We will, Melanie, I'm going to ask that you stay, okay? I'm going to talk to the lawyers off the record, but we're going to put in, I'm going to ask that you stay through that conference off of the record so that we can put it on so that starting hopefully Wednesday at 9 a.m., I would read a portion of the jury instructions up until the point, and this is where I stop. I don't know that you all have tried anything with me, Mr. Dreiser, Mr. Hill, Ms. Day. So what I do is I read up until submitting the case to jury. Oh, no, I'm sorry, rules of deliberation. So I stop there, and then I don't read rules for deliberation. I stop right before then. I let y'all argue. Then I pick up after that, submitting the case to jury, the verdict forms, and then they would retire after that for their deliberations. Does that sound okay?
Yes, ma'am.
And does the court envision that doing that Wednesday afternoon? Or waiting until Thursday morning? I guess since we have a waiver, it doesn't matter.
Well, I would let them deliberate late. I mean, late, like 8, 9 o'clock, and then
Understood.
let them come back if they can't reach a verdict. So if we start at 9, these jury instructions aren't that long. So I would envision that they would possibly get the case early afternoon. So they would have 6, 7 hours to start deliberating.
And is there any chance of doing the closing tomorrow, even if it's a
No.
bifurcated proceeding?
I wouldn't do that. What I would do, I will give y'all, so what we would do the charge conference, we break so that you all have plenty of time, you're rested, the jury's rested, so that you all can work on your closings, you'll know what the law is. That would be my plan.
Yeah, just hashing it out really informally with the state. It's probably going to be like states close in the morning, defense close in the afternoon, then deliberation, given the time that each party thinks they'll go.
I read about a minute or so a page, and so the opening instructions are about 20 pages, so that's like 20 minutes, give or take. And then, so you think your closing would be
Say she does.
all morning?
Well, if she does, let's just say she goes a couple hours, then I would say, I
You need
would
a
probably
break.
request that they get maybe an early lunch, and then I go. Maybe we just,
Lunch is like a clockwork, Mr. Dreiser, so it comes at like 11.
I would tell the court probably an hour 30 to hour 45, but build in a little extra time for that,
so,
just in case.
So for your first close?
Yes, ma'am.
and then if I'm long, so just,
Okay.
so I would still want to, that I would like to not be broken up. Like, I don't want to, and then take a lunch.
Would y'all rather than just come back the next day and deliberate?
I think it depends. Let's say we take a lunch.
I'm trying to give them a whole day. I could start the instructions at 8:30 if that would help.
Can we discuss amongst ourselves and come back to the court with some kind of better idea of scheduling? Now that I'm hearing this, I'll speak to Mr. Dreiser about how many witnesses tomorrow. It's conceivable, rather than breaking up that way, I could get through first close tomorrow afternoon, depending, but I need some time.
I
to
think
talk
that's
to
a
him.
really strong possibility.
So let me propose this. So for your discussions, you don't have to commit. Let's say the defense finishes relatively early. We have our charge conference. I don't think it's very complicated. It's very straightforward. There are a couple of things that I'd like to talk to you all about tonight that I think would help. Would you like for me to read the instructions, send them home, and then start your closings in the morning, first thing? And then would that help? So in the morning, if they start at 9, they essentially have 4 hours. And then, do you think you could get it done by then?
I think have an entire afternoon.
Right.
because I like to get, have them rested. It seems silly to waste that time. From the state's perspective. I think that the thing that makes the most sense is that we do the defense case, we have a charge conference, we have a large break for lunch. Stifler does her closing, we come back fresh on Wednesday for Mr. Dreiser's closing and rebuttal. Then they get their case much earlier in the day.
When would I be reading according to your plan?
Right before Ms. Stifler does her closing.
So 20 minutes, you would, okay.
I think we're gonna have a full hour.
I think he may be right.
Right, that will give us 4 hours, and that's plenty of time to get the instructions and first close done tomorrow afternoon.
And then it'll be the next day, defense close rebuttal case.
Mr. Dreiser gets a overnight to think about it, so
I think it nurse is good.
it does.
I'll
Okay.
take it.
You're also giving him extra time to like figure out what to say,
Yeah,
longer and longer.
God,
Give me extra time.
I probably couldn't do it without that extra time, but thank you. I'll take it.
I'm joking. All right. Okay. First order. All right, we'll be done for the day then. And I want to see the lawyers at sidebar because I have a few questions that will help me. I'm going to push the jury, my draft of the jury instructions out to you all. Okay. No, it's just, I just have some questions before all right, court's adjourned. Thank you all very much.